Item 7, ma'am.
items.
Next week, any date?
At request made by the. Admit that. Third of September.
Madam,
Item number-
Another my lord, prayer, my lord, for listing, my lord. This case came up last, my lord, on 4/8/25. If possible, on 4th of,
Lots of matters have been already fixed. Let us see.
4th or
then,
5th?
Don't know.
Fifth.
Fifth.
I'm obliged.
But I beg to mention item number 5, only for pass over product. For clothing.
Item number 5.
5. Next week, any day.
Next week, though, I don't know.
Sunday.
Maybe by 8 or 9. 8. Passed over to 9. 9.
May it please, your lord.
8 at the request crooks.
So pray for listing of a criminal petition. It's a POCSO and suicide case and we are for the victim. There is already a stay order, but the matter has not been listed. So for admission, my lord, any date convenient, my lord. Next week or day after, week thereafter, my lord.
And then next week or
Week
Yeah.
thereafter, the week thereafter also.
either next week or thereafter. 9, 12 is a holiday. I don't know why. Right. 11th of September.
Date you, may.
May please, your lordship. Lordship, I beg to mention for listing on criminal petition. May I pray on 5th? May I pray on 5th? madam?
Let us. Fifth.
Because my lord,
Okay.
next date is 8th.
5th of.
May I please, your lordship, I beg for listing of one criminal petition. Lordship, can it next week?
You have seen already. There are many matters. It will be at best will be listed on 8th of September. 8.
May I please, your lordship, I beg to mention item number 47 of supplementary list, my lord. Kindly, this matter may be come up along with the AB number 1907.
47
1907.
was a supplementary.
Yes, my lord, supplementary list, 47.
Supplementary item number which one?
47. 47.
47.
Yes, 47.
And what is your AB number?
AB number is 190725.
1907/25.
25.
Is there any listing the date of
Yes, 29.
2nd of September?
Second of,
Why this cases with this before this court?
my lord.
On 2nd of September, this case is listed in before this court or this bench before or any other?
No, any other bench.
Oh, you want to, oh, I thought that it's, no, then you make a motion, make a mention before court number 16. We are not taking the regular bail.
No. Today is, I want to adjourn the matter, my lord, and take the matter along with that AB number, my lord. That is fixed
Why
on.
this, can you tell us why the petition is before this court? Why before this court?
No,
Under
earlier it
executive-
was withdrawn, my lord. Once it was withdrawn.
Hey, we don't know anything. Very strange.
For hearing, man, this time this was for hearing.
Whatever, we should not come here. Because as what I'm saying, you're not taking the regular bail bench is there. That's why I'm asking, otherwise no issue.
AB is the decision, I think.
Acha, what is the, and anyway,
Is it-
your number 47, na? 47.
47.
I think it's made by so and so, matter is adjourned. List the matter along with AB number, will listen.
1907.
AB number so and so. Good stuff. Okay.
I'm obliged, man.
May I please, your lordship?
Yes.
Lordship, I beg to mention for listing of a criminal petition. Any date, your lordship.
9/9.
Right. Obliged. my lord.
May please, your lordship, I beg to mention a criminal petition for listing on any date next week.
Yeah, 9/9. 9th of September.
Obliged.
Same prayer, lordship.
9th of September.
Can it be on next week, lordship? On last
Next,
occasion, it was listed
uh,
due to paucity of
Just
time. It
verify.
could not
Next
be.
week, can it be? 4th of September.
Very much obliged.
Yeah, please, Lordship. Lordship, I mentioned a criminal appeal earlier, Lordship, and it was supposed to list today, but it is not listed. And it is informed from the concerned finding section that file is not be testable. So can it be on Monday?
That is not our issue.
Lordship, it is
And
not
you can
listed
verify
today.
why it is not listed. It is not registered.
Not listed today. I mentioned the criminal appeal to list earlier, Lordship. And it was the
List
date
earlier means, this earlier means,
on 20 of this month to list the criminal appeal.
Huh.
And it was allowed and it was supposed to list today, but it is not listed.
that's why we are saying that we are all are pressing for listing and all. Why don't you go to registry, I mean, the section, concern section and make a mention there, because there are maybe some situation, maybe some reasons for that. Most probably that is the reason why it has not been listed.
Lordship.
Anyway, at best we can list it 4th of September.
Fourth,
4th of September.
Well, regarding item number 25, this was listed on 22nd, and on the
25.
item number 25, my lord, it's been wrongly listed today because on 22nd it was directed to be listed after 2 weeks, and record was also not there. But again, it has been wrongly listed and shown as by order, man. Both sides are present, man. So let it come up, my lord, as earlier fixed, my lord,
Earlier it was,
after 2 weeks. It was fixed on, it was listed on 22nd of
Huh.
this month.
and
And it
after
was
2 weeks.
directed that it was to be listed after 2 weeks. And records were also not there. So records were called for, madam. But again, it has been listed.
So it will be again listed for after 1 week or
After
let
1
it
week,
be
madam.
after 1 week?
After 1
Because
week.
2 weeks will already be
Yes,
there.
ma'am.
The consent will be asked. Done it comes for repetition, Mr. S. Thomas. Wait for an adjournment, submitting that matter may be listed. Prayer and is the matter. As an
Interim
edit
may be
fixed by
continued.
the registry. As an edit fixed by the registry, interim be continued. in registry.
Deep.
My lord, I beg to mention criminal revision petition number 214 of 2025 for cancellation of bail. My lord, the last date of posting was 15th of July 2025. A sooner date may be given, my lord.
Cancellation of bail or উনি দেওয়া উচিত। উনি কাট করতে গেছে। বলবো, এই ব্যাপার। 4th of September.
Lordship, I beg to mention item number 33, the speech
33.
for CD is diary. 3, that is. Denied.
CD not received. Are you on interim day?
Lordship,
Was there any entry?
no interim.
No in. CD not received. Issue reminder. Yes,
Even
Usami, they are not on interim.
Yes,
Management
madam.
leave.
She's acted under 11th, madam.
11th of
11th.
September. 11th of September. Before that, may not reach, I don't know. Let it be on 11th of September itself. We may try.
No, 9th, madam.
9th, okay. 9th.
We'll see.
deeply well.
Lordship, I am pleased to mention that criminal petition 143 of 2024 has not been listed since February 2024.
February 2024.
Yes. So matter may
You
be
didn't
listed.
approach before the registry or the concerned section? Because 2024, February 2024 is quite a long period. In fact.
Matter is still continuing in the lower court.
No, continuation is a different aspect, but the question is that you have filed a criminal petition before this court. Maybe what may be the prayer, I don't know, but the question is that we have already filed. Okay, it will be listed by 4th of September, 4th of this month. 4th of September. September.
Eighth is your lordship. Your lordship, I beg to mention a criminal petition, your lordship. The matter is pending before the trial court on, it is listed on 8th of September, your lordship.
18th of September.
8th of September.
8th of September.
So your honor,
Okay, then 5th of September.
your honor, prefer the 3rd or 4th if your honor may.
4th of September.
Oh, bless.
Please, your lordship. Lordship, I want to withdraw this petition, lordship.
Pardon?
I want to withdraw this petition, lordship.
Withdraw this?
Yes, lordship.
Your good name is Vijay Datta?
Yes.
As per instructions of the
Yes,
plan?
yes, Lordship.
As per instructions. PJ Datta. Okay, it will be disposed of on withdrawal.
Lordship, obliged. May I please, your Lordship? Lordship, here, Lordship, the impugned order, Lordship, I will start from the impugned order, that is, Lordship, at page number 83, Lordship.
Page 3,
82, it starts from 82, Lordship.
page 82.
Page 82. This is an order, Lordship, passed under section 143A of the NI Act. Lordship, may kindly come to page number 82 first. Order dated 13/3/2025.
Hmm.
May I read the order, Lordship. Only two
Hmm.
paragraph I will read. Lordship.
Hmm.
Complainant is present and duly represented. The accused person is present, represented by so and so. Today, the matter is fixed for order on petition number so and so. Peruse the petition 2189 filed by the complainant, height who is free to direct the accused person to pay interim compensation of 20% of the said amount to the complainant as per section 143A of the NI Act. I have heard the learned counsel for both the side on petition number so and so. Before deciding the issue, let us now peruse section 143. Thereafter, Lordship, section 143 has been discussed. Now, Lordship may kindly come to the next page. After clause number 5, in the present case, the accused side had filed objection against the petition number so and so. I have perused the same. Accused side stated that accused person has taken a loan of rupees 3 lakhs only from the complainant, and as a security for the said amount, 3 lakhs, the accused has issued 3 checks on so and so, so and so. However, taking undue advantage of the said 3 numbers of blank checks, the complainant forced the same and put manipulated amount by his own to misappropriate the same and so and so. Thereafter, Lordship may kindly come to the next page. Next page, Lordship, last paragraph. The present case is at the stage where the offense explanation has been done. The court is satisfied that a prima facie case has been made out against the complainant. Relying on the decision of the Honorable Apex Court in the case of Rakesh Ranjan Srivastav versus State of Sarkant and another, this court directs the accused person to pay 15% of the amount. Now, Lordship, this petition number 2189, on the basis of which this order was passed, Lordship may kindly come to page number 56. This is the petition. May I read it, Lordship? The complainant stated that the complainant filed the instant case against the accused person. The accused person above named have entered appearance and offense were explained to him, which he pleaded not guilty and claimed to be. The complainant states and submit before the Honorable Court to allow him the interim compensation of 20% of the check amount at the stage from the accused person. The prayer portion, it is therefore prayed that the same thing is there, Lordship. Now, Lordship, the ground, Lordship, on which I am assailing the impugned order is, Lordship, in the petition, there is no ground as to why the 20% amount has been given. Even, Lordship, the check amount has not been mentioned. The proposition is well settled, Lordship. I will rely only two judgments, one by your Lordship. And
Some
another,
observation is made, isn't it? It's not made any observation.
no, Lordship.
No observation.
Nothing. In the petition itself, Lordship, nothing is there. Lordship may kindly come to the judgment, Lordship, that is passed in criminal revision petition 485. This is a judgment by your Lordship. And Lordship, in this case, Lordship, that Rakesh Ranjan Srivastav has been discussed. Therefore, Lordship, I am not referring that. Lordship may kindly come to paragraph number 15. 15 to 20, I am relying on, Lordship. By order dated 12/7/2020, it has been observed by the learned court below that accused appeared on so and so, where he pleaded not guilty. The complainant has not mentioned any reason in the petition as to why he should be awarded with 20% of check amount. Further, it has been observed by the learned court below that in the instant case in hand, the accused has not unnecessarily affected the proceeding by seeking adjournment as to as the delay was caused not only for the fault of accused but due to non-functioning of the court's work during the pandemic. Accordingly, the petition awarding 20% of the check amount as compensation under section 143A of the NI Act was dismissed by the learned court below. The learned SDJM had discussed in details about the judgment of various high court, wherein it has been held that provision is directory and not mandatory in nature. However, in some high court had expressed the view that it can be considered as mandatory provision. Now, Lordship, paragraph number 16, once again, Lordship 143A. Now, Lordship may kindly come to paragraph number 17. Thus, as per section 143A of the NI Act, 20% of the said amount may be awarded as an interim compensation in the case if the drawer pleads not guilty to the acquisition made in the complaint and after framing of charge. Here in the instant case, it is seen that accused pleaded not guilty at the time of offense explanation, but there is no ground taken in the petition. No ground taken in the petition as to why there is a need of 20% of the said amount as compensation under section 143A of the NI Act. More so, from the record, it is seen that the order passed by the learned court below, that delay is caused not for the fault of the accused respondent number 2, but there was fault from the complainant side as well, as the matter was delayed for non-functioning of the courts due to outbreak of. However, it cannot be denied that the accused took several months to appear before the court. In the same time, it is seen that amended provision of section 143A of the NI Act also cannot be considered as mandatory provision, as there should be some reasons to pass the order on interim compensation as per section 143A of NI Act. The Honorable Apex Court in the judgment so-and-so, Rakesh Ranjan Srivastava versus so-and-so, it has been discussed in details as to whether the provision under section 143A is mandatory, directory or mandatory, and also expressed the view that the word may used in section 143A cannot be constituted or interpreted as shall. It all depends on the nature of the power conferred by the relevant provisions of the statute to the effect that so-and-so. The legislative intent always play a role in the interpretation of such provision, even in the context in which the word may has been used is also relevant. The Honorable Apex Court also expressed the view under the said provision, if the accused have paid interim compensation up to 20% of the said amount, such an interpretation will be unjust and contrary to the well-settled concept of law. Thereafter, Lordship, paragraph number 14 has been discussed. Now, Lordship may kindly come to next paragraph 20. Further, in the case of Rakesh Supra, the Honorable Apex Court had held that while granting interim compensation, the court shall apply its mind to the quantum of interim compensation to be granted, and also by considering various factors such as nature of transaction, the relationship, etc., before passing the order. And in the same time, it is found that there is prima facie plausible defense, the court may exercise discretion in refusing to grant the compensation. Paragraph number 19 of that said judgment was quoted, unquoted, Lordship. And thereafter, Lordship was pleased to decide that as because there is no ground in the petition, the petitioner has not mentioned any ground as to why the award should be given, that 20%. So Lordship was pleased to pass this order at paragraph number 22. Here, Lordship, if we go by the 56, the petition, he has not said a single word. Even, Lordship, the check amount is not mentioned here. Nothing is there, Lordship. So, Lordship, my humble prayer is that, Lordship, Lordship may issue notice, and at the same point of time, Lordship may kindly suspend the impugned orders. And Lordship, in the impugned order also, Lordship, no other factors, our defense, which we had submitted our written objection, those things were not considered. More particularly, Lordship, in the entire petition, there is not a single reason as to why the 20% should be awarded. Yes, please.
Pardon, sir. Next petition. The sections which telling the order dated 35, whereby the interim relief of 15% was granted, check amount was granted to the respondent. Issue notice to the respondent, no formal notice is required to be served on state respondent number 1. However, a copy of the petition may be served during the course. also called for discussion. Next one. Heard on the interim relief is submitted by Mr. So you want to, for the stay of this
Yes, Lordship.
entire proceeding or the
No, no.
order?
Only
Only order.
that order, Lordship. Let the proceeding be continued, Lordship. I don't have any objection.
Is submitted by Mr. Ahmed that during the pendency of the case, the respondent as a complainant filed a petition seeking 20% of the check amount as an interim relief under section 143 of the NIA. And considering to which the respondent petitioner also filed a written application, but without making any observation on the objection filed by the petitioner, and without any reason, the learned trial court below had passed an order directing the petitioner to pay 15% of the check amount as a compensation under section 143A to the respondent, provide its order dated 13/0. Mr. Hamid further submitted that the petition which was filed for seeking the compensation also does not disclose any reason as to why the respondent need a 20% of the check amount as a interim measure under section 143A of the Act. Accordingly, submitted by Mr. Ahmed that execution of the implement order dated 13/5/2025 may be stayed in this point. Next, during his submission, Mr. Ahmed also relied on a decision of this court passed in criminal petition number 1485. 485 of the 22 in this context. Next, hearing is submission made by the constitution, considering all aspects of this, and also considering the fact all other aspects of the case. The execution of the order dated 13/5/2025 in respect of paying the compensation is stayed or suspended till the disposal of the petition. However, the case may be proceeded. Please the matter.
Highly obliged.
Miss Your Lordship. My lord, on this last occasion, my learned friend was, my lord, directed to obtain instructions. The order which has been impugned in this petition, your lordship will find at page 373. I'll read that order.
Mr. Chaudhary,
Yes,
have you
Yes,
obtained the
yes, my lord. No, what happened, your lordship will kindly see page 373, my lord. My lord, my learned senior friend is agreed by an order, my lord, whereby, my lord, the learned trial court has sent a copy, my lord, a purported LS copy for FSL once more, my lord. That was taken by the IO for re-verification, my lord. That has been challenged by my learned senior friend, my lord. But that is an order of 13/6/2025, my lord. But my lord, after taking out that, the IO has placed it before the FSL and some report has also come, my lord. That report, today I don't have it, my lord, but I have the instruction that as per this, my lord, letter, my lord, the FSL has, my lord, a verification was done, my lord, and a report has come.
The report already submitted
Yes,
by
report
FSL.
Yes, already submitted. So my learned friends, senior friends, my lord, or my lord, direction, my lord, silence is, my lord, regarding stay, my lord, agree by that order, my lord. But now, my lord, that perhaps that doesn't survive now, my lord. so far the, my lord, report, since the report has come, my
Just a sec. I mean, by 3/6/25, an document was again
Yes.
sent for FSL for
FSL.
re-verification.
Yes, yes.
Whatever.
They challenged that order, my
That order was been
Challenged.
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 You are now submitting that. The
already it
matter
was sent
has-
for FSL and the report
Report has already come.
and,
Mr. Chaudhary, that be the position, I don't know, whether, what will be the, I mean,
My lord.
as per him, I have not gone through any record,
My lord.
but as per him, that you have put to challenge it, order of 13/6/2025. Challenging that it has been sent for, it should not be or whatever. But the question is that a report has already come. So, whether we should await for the report or want to submit any.
My lord, so far the report is concerned, my lord, whether the report has come or not, that will not have a, my lord, real bearing on the, my lord, decision
this-
your lordship will
Okay.
eventually take, my lord. I'll explain if your lordship give me some time, my lord. Your lordship will kindly read the impugned order, my. Because what happened, my lord, this order was passed on an off date, in an application filed on an off date, and the, my lord, accused persons, the petitioners were not aware. And my lord, the fact that, my lord, the same report was sent twice before the Forensic Science Laboratory, and my lord, it said that, my lord, signatures are genuine. My lord, suppressing that fact or misleading this, my lord, the court, this order was obtained. So that was my grievance, my lord. Firstly, the same report was
The
sent twice.
signatures were genuine. That report was earlier submitted before the court.
Twice, my lord. On 2 occasions, it was sent to the, my lord, Forensic Science Laboratory. The allegation of the informant was that I have not signed it. Now his samples were sent, and my lord, thereafter on request again, my lord, it was sent to the FSL, and both the occasions, my lord, a clear report of finding was given that the document was signed by the informant. In spite of that, my lord, this application was filed on an off date. Behind it was passed on 13/6/2025, my lord. Since it was passed on an off date, we did not know in an application filed on an off date that was passed. Therefore, my lord, whether that document can be used, my lord, that will be admissible or not in the evidence, that your lordship will decide in this petition. Therefore, at this stage, perhaps,
Whether that can be decided in this case.
my lord, because if the order goes, my
What
lord,
is your prayer? Let us see your prayer.
my prayer, your lordship will find at, my lord, page
page 21, okay?
21, 22.
22, my lord.
In the premise aforesaid, it is most probably prayed that your lordship may be pleased to admit this petition, issue show cause notice to the respondent, and on such cause of being shown after hearing the parties, may be pleased to set aside and quash the order dated 13/6/2025 passed by the learned CVM Morigaon in case number so and so. So, my lord, I am praying for setting aside that order, my lord, on several grounds. One ground is that it was passed behind our back. Second ground is that, my lord, the application that was filed was my lord, misleading. And by misleading the court, my lord, this order was obtained. In the event, my lord, we are able to satisfy that, my lord, it was by misleading the court, my lord, your lordship may interfere with this order. In that event,
But another question here is, yes, I have submitted in the 2 occasions that has already been sent for FSL and report is already submitted before the court.
my lord,
But behind your back or whatever, that again it was sent.
yes.
Now, we don't know at this stage what is the report. In fact, whether the report says that obviously it is a genuine signature or it says otherwise. That is not before us.
That is not.
So, Mr. Goswami, we can do one thing. Is this matter may be fixed for admission hearing, so that matter may be heard and finally decided,
My lord.
not in a motion column.
My lord.
I think so that will be better because otherwise, if we hear your, I mean, this petition, the report may say otherwise also.
In the event,
in
my
their
lord,
favor
report
also.
goes in my favor,
Your
Then-
favor,
then-
then,
then, my lord,
then the
There
question
will
of
be no
this,
case, my
Yes.
lord.
then the question of
Yes,
this
it might be
will
go
not-
to the, in my lord's
But
senior
yes, if
favor
it is
also.
goes otherwise or if against you, then in that
Only
that
some
may be a case.
deliberation
That
will
may be a
be-
case for why it is sent for
Yeah,
interview
lordship,
occasion, why
right,
it has
ma'am.
been sent.
But then, my lord, I'll also pray because, my lord, this has been done very surreptitiously. I'll also pray, my lord, let them produce my lord, the report of the FSL that was sent to Chandigarh, as well as my lord, the sample signatures that were sent. Because we are trying to point out before lordship, my lord, I'll point out from the records that, my lord, the design is that, my lord, somehow or other, the particular document to be my lord, exhibited against us, showing it to be not genuine, although, my lord, there is already a finding, my lord, by the police itself, my lord, the earlier FIR on the basis of which this matter is going on, my lord, that the FIR was false. There was a final report, my lord. Thereafter, there was an application for further investigation that was, my lord, allowed. We have come for quashing that, my lord. That is a separate issue not connected to this. Then, my lord, this FIR and that particular document, my lord, we have never used. And this FIR was lost after the writ petition was filed. What happened, my lord? We were appointed in 1999, and my lord, when the schools were not provincialized, subsequently we were regularized. We came before this court asking for salaries, and this honorable court, by a very reasoned order, said that the salaries should be disposed of, because our case is that we are not getting salaries. Some other persons who were joined together, similarly situated, they are receiving salary. They are receiving now also. So, my lord, this honorable court directed that we should be paid our salaries. Against that, thereafter, my lord, this FIR was lost on a document which was we never used. Then, my lord, they filed a review. The state filed a review. Review was rejected. Then they filed a, my lord, writ appeal. Writ appeal was dismissed. The state went to the Supreme Court. Supreme Court also dismissed their SLP. Thereafter, my lord, they again came and, my lord, filed an application after the final report that, my lord, the further investigation.
They're facing contempt.
And there is a contempt case pending, my lord. We are not even not now, my lord, getting, some of us are getting, my lord, salaries. Area salaries have not been released. Contempt is, my lord, pending. And therefore, my lord, the authorities are such. And it is a case your lordship will see. FSL Assam has given 2 reports. It's a, my lord, department of the government. My lord, the education department is questioning the credibility of the, my lord, another department of the government and sent it to, my lord. Your lordship will
But
see.
there are some instances where I have also seen that bypassing this Assam Forensic Laboratory Sciences, it has been sent to the other states and all. There are some instances.
That
May
can
not,
be-
I don't know why
That
this has
can
been
be done, but, my lord, that is unfortunate, my lord. Your own department gives 2 reports and you do not believe that and try to get another report. Anyway, my lord, let him produce. But along with that, my lord, the sample signatures may also be, my lord, produced. Because, my lord, earlier,
That might not be required here, my lord, because if my lord, only my lordship may kindly go to the report, as your lordship has indicated, and my lord finished in your favor. My lord, what if the report comes in your favor, there is no point, my lord, keeping harping on everything, my lord. If on the merit, I can submit everything in the merit, my lord, since the search sheet has also been filed. There, my lord, after my lord, further investigation is, my lord, ordered, my lord. They have also preferred a revision before the, my lord, session judge. That has been rejected, my lord. Thereafter, my lord, it was ordered for investigation and my lord, the report has, my lord, final report submitted, my lord, search sheet submitted, my lord. So merit is otherwise, my lord. And regarding what my lord friend is saying, my lord, regarding the fact that the salaries and the appeal, my these should not be clubbed together, my lord.
No, it
Yes,
did not come. That's
yes,
Mr.
it's
Chaudhary has
it's a
just submitted that
repetition, my
these
lord.
are the
This is
things
now
also
we are in
pending.
my lord, criminal petition.
Otherwise, this will not
Yes,
bear any effect in
yes,
this
my lord.
case.
So I praying, my let us wait for what has been
Okay.
there, my lord. If it is in my
Should
lord,
I
senior
put
friend's
it for
favor, my
your
lord, there is
admission
no
column?
harping on all this.
Let it be on admission column then,
Yes,
that may be
madam.
finally heard
Yes,
and
yes,
decided.
yes.
Your report, as per your instruction,
Yes.
report has already been submitted.
Yes, yes.
So you just want to obtain the report.
Yes, obtain report and place before it, my lord.
that is fine, my lord.
And
But
if it
then,
is-
notice has to go to the informant also, my lord, to notice.
Notice is not
Yes,
yet.
notice may
Notice
be,
has not
notice not issued, man, it may be issued.
Achha, achha.
And, my lord, I'll have a further prayer, my lord. Whether that document can be used or not, that will be subject to the result of the case.
Yes,
my
that
lord.
will be subject to.
That your
yes.
lordship may kindly observe. Admissibility of that document will be subject to the result of the case. I am not praying for stay of the proceedings, my lord.
So informant, how many?
Informant is responsible for 2, my lord.
Abdul. Who is he in fact? Who is
My lord,
he?
he was a, my lord, former district elementary education
Oh,
officer.
achha.
He is the informant. He is the
He is the
informant.
Part Mr. M.K. Chaudhary, the learned senior advocate, assisted by Mr. M. Datta, the learned counsel for the petitioners, and also part Mr. M. Goswami, the learned additional PP, appeal from behalf of state. This submitted by Mr. Chaudhary that notice is not yet issued. on the respondent number 2. Did the notice be issued to the respondent number 2 to register AD and judicial process? Further, it is submitted by Mr. Goswami that the FSL, as per his instructions, the FSL report has already been received by the investigating officer from the FSL, is this Chandigarh or what?
Chandigarh.
Chandigarh, FSL Chandigarh. In view of this, the additional fee is hereby asked to furnish the report, FSL report prepared for this court on or before the next set of listing. And it will be in a motion column itself, otherwise it will be made difficult.
No.
Matter may be listed is how many weeks, any
But
weeks you need?
after notice, my lord, it has to be in admission, perhaps, my.
The matter may be immediately listed before this court in admission column. After matter may be listed immediately after the receipt of the service. Sorry, after receipt of the service report on respondent number 2. Respondent number 2. What you have submitted, it bearing it that for Swedish.
The admissibility of this, my lord, document will be subject to the result of this case. If your lordship eventually, my lord, dismisses this petition because it is in our favor, my lord, that is the end of the matter. And if, my lord, not, then your lordship has to decide whether that can be, my lord, accepted in the evidence or not.
Yes, Kusami, anything.
But that, my lord, would not
May
be, because now the challenge that has been made, my lord, already, my
not
lord,
be reflected,
report
it
has
will
come, but-
become automatically.
Yes,
Yes.
because
Then we can prospectively just be listed after 3 weeks. We'll
Lord,
list after 3 weeks. We'll see to it.
But in the meantime, my lord, they will be using in the trial.
Pardon?
They may use that in the trial against us. That has to be, my lord, therefore some observation that will be subject to the result of the case.
that will mount to, my lord, perhaps it will amount to stay of the, my lord.
That's why, my lord, I wanted to show you, my lord, the application they filed by misleading the court and, my lord, the order they obtained.
My lord, misleading part, my lord, I just have objection to that, my lord. My lord, all the documents are before the trial court, my lord. So, my lord,
Or can we that considering your submission, can it be made this way? The report of the receipt FSL report may not be used in the evidence till disposal.
Yes.
no, my, that may not be, my lord, because that will create ultimately, my lord, we are
In fact,
going
my
for
lord,
the stay of the proceeding in that case, my lord, if that is because if we,
In fact,
if
my
any
lord,
order is passed, my lord.
all the accused have
That
not
cannot
been
be
served till now, my lord. All the accused have not been served till now.
So that is why what I am saying, my lord. The lordship may fix a short date also, my lord. If the report comes, my lord, then
Okay, then we can fix a date in fact.
short date,
Date
my
of
lord.
the auction.
Next,
Till the next date, my lord.
my lord.
9th of September, very short date.
Lordship,
9th of September.
that is all.
Because-
Everything will then separate proceedings will be started, my lord, with on the basis of report, my lord, whether we have to my lord, deal with this petition or not, my lord. So then it will be very much clear, my lord, without going
Yes, obviously, and some of the accused persons are yet to
Yet
appear, I think.
appear.
So
it will not
probably
be
it is that
any
within a
effect.
very short period, evidence may not be.
Evidence may
not.
absolutely, my lord.
Okay. 9
Okay.
9 to
9, my lord, very short.
It will not affect you, Mr. Chaudhary, because there are, as you have submitted it, there are still some accused persons who are yet to there. So it will take them. So that's why we are keeping a very short date on 9th of September. Let us see.
Lordship.
If by 9th of September, even if suppose we receive the service report on the respondent number 2, but
Then
we
also
may
can-
hear the matter and we can dispose.
Lordship.
In absence of the informant. And
Some observation that, my lord, some
it's
observation
okay.
reported.
It may affect the case proceeding.
Lordship. I'm okay.
Nice.
Because ninth of-
Goswami may assure you within 9th of September, there may not be any such
No, but there will not be any date.
trial may not be proceeded.
Yeah.
9th of September is fine. Obligation. Whether I was just, my lord, worried whether the notice service will be complete on Resonar Road 2 in the short
That's what
period.
I'm just saying, that even if suppose services
No.
awaited, in that case also, if report received, then we may hear the matter also. Or if it goes by in favor, in your favor, then to matter definitely it may be otherwise. Or if it goes against to, then other this part we may hear.
Okay.
Open. Can I please look at the matter? Dates are. So these parties are not used to it. Yes, 4.
May it be pleased, Lordship, by this petition, my lord, I have challenged the impugned order dated 10/1/2023 regarding the enhancement maintenance given to the opposite party, and that order has been passed ex parte, my lord. But here in this case, my lord, in a short, the opposite party is still residing in my house, along with my 2 sons. Both the sons are major, and the landed of my landed property they are enjoying still. Now the dispute after 25 years of their marriage, dispute arises because of the fact that my old ailing parents there, and one of my brother is subsequently mentally retarded. So now I have to maintain them also. So she debarred me to maintain them. That is the only issue arises, and I am posting in another places. I have been serving in the industrial security forces, madam, and I have got near about 50,000 salary now. So I have no problem to give the maintenance also, despite that, madam. The only problem arises that this impugned order has been passed from the date of application of the enhancement. And that's why there was area near about 3 lakhs. So now being a constable, he got the 50,000 only salary, and maintaining his old ailing friend, retarded brothers and sisters, even his sons also sometimes taken the money. So if the 5,000 enhancement has to be given from the date of order, my lord, that I have no objection at all. Because at this stage I am not able to keep the area amount. With the last time, my lord, this learned court below directed me to pay the area amounts. And the application has been filed for enhancement in the year 2018. And the order has been passed in the year 2023. And that order has been passed ex parte. So at this stage, my lord, my humble submission before your lordship, I may be continued with the enhanced maintenance also, because 2,000 maintenance earlier given, I have continued without any default. So I'm ready to pay. So let the continue with the enhanced maintenance also. In respect of the area part is concerned, my lord. At this stage, that part may be statement by issuing a notice to the opposite party. That is my humble submission.
Where is the order?
My impugned order is at page 47. The relevant portion is at page 49. The enhanced maintenance allowance is required to be neither excessive or oppressive for the second party. Accordingly, the 3,000 per month is deemed to be just a reasonable enhanced amount. As the case has been proceeded ex parte, in the light of the above discussion of the facts and circumstances made so far, I deem it fit and proper to set the quantum of the enhanced maintenance allowance at the rate of rupees 5,000 for the first party. The second party is accordingly directed to pay the enhanced monthly maintenance allowance of 5,000 rupees 2,000 plus 3,000. For the first party, Rani Boro, the enhanced maintenance is to be paid from the date of filing of the petition for enhancement of maintenance allowance under section 127 CRPC, that is 2/11/2018. And in fact, Malad, the 2,000 maintenance which has allowed long back in the year 2016, I have been continuing with that payment, Malad, without any default. And even Mala, she has a sufficient means because she used the landed property. She is
The
still.
order of this, your area amount?
My lord, now the as per the last order of this honorable of the learned trial court, my lord, the 2,39,000.
Where is the order?
My lord, that order subsequently I have got it. This order is at 28/2025. The matter was fixed 38 again. My two sons, they are also business. They have a sufficient means to income.
Is
And
no prayer on your petition?
my lord, on that day, my lord, she could not appear because she has given some duty. Not in summer, she contacted me.
No, your petition does not, I mean, it is not here about the prayer for this other prayer, that is the area amount and also. We are
Yes.
not going to pass this anyway. Heard Mr.
R. Islam.
R. Islam, the learned counsel for the. What, there are numbers of advocates' name has been mentioned here? 1, 2, 3, 4, 5, 6. 6 numbers of advocates' name has been reflected here. They have already entered into evidence.
No, my lord, actually what had happened in this case, the interlocutory application was filed for condonation of delay. In that case, they have appeared. But after condoning the delay, this case has been listed today. And I think, my lord, that name has been shown.
So in that case, we have to take issue fresh notice.
Yes, lord, issue press.
Counsel for the petitioner. Full stop. No one has represented the respondent side. No, the name of 5 numbers of advocates are being reflected in the cause list. However, it is submitted by Mr. Islam that during the disposal of the interlocutory petition filed under Section 5 of the Limitation Act, the advocates appeared on behalf of the respondent and participants. In view of this, let a fresh notice be issued to the respondent registered agent and process. Also call for the scan history. Further, considering the submission made by learned counsel for the petition, the petitioner is hereby directed to pay the maintenance enhanced rate of maintenance from the date of impugned order, that is 11/1/2022.
Yes. No, no, my lord, yes. My submission is
Enhanced amount is
enhanced order is my lord, 10/1/2023. And the
10/1.
date of filing of their petition is 10/1/2018.
Why you have mentioned in your prayer portion 11/1?
I think
Order was 11/1 or 23?
23. Well, it's
Oh,
page
sorry,
47.
11/1/23 or
Page 47. Page 47 is the, oh, sorry, my lord, 11/1, yes,
11/1?
11/1/2023. sorry.
Correct? Directed to? 2023, and the portion of the order wherein the petitioner was directed to pay the enhanced rate of maintenance from the date of filing of the enhanced petition for enhancement is stayed or fixed suspended till next date of listing. List accordingly up.
Much.
Please.
It's a quashing petition, section 528. If now cognizance has been taken under section 376, 417 and 506. Otherwise, Lordship, the FIR, prima facie, Lordship, perusal of the FIR would suggest that the victim is a consenting party, and it's a settled proposition of law that mere refusal to marry without the any initiation of cheating from the very beginning would not constitute an offense under section 375, Lordship. It's a settled law, and a coordinate bench of this honorable court, while granting prayer as well, has also reiterated that position. That Lordship will have at page 30. While granting bail, the informant had love affair with the petitioner. They had physical relationship in different places of the state. It is alleged that finally the petitioner refused to marry the informant. It is a settled position of law that simple promise of marry offense. Then in such a case, the person can be tried together with the accused. Coming to the matter in hand, upon going through the evidence on record thoroughly, it appears that the prosecution witness, who is the sole victim of this case, has specifically stated incriminating materials against accused so-and-so. Upon giving the matter due deliberation, this court is of the opinion that it shall be miscarriage of justice if Talha Raj Borbhuya and Moinuddin Raj Borbhuya, they are the petitioners, my lord, are not implicated in this case as accused along with the present accused person. In view of the foregoing discussion, this court deems it fit to implicate so-and-so in this case, exercising the power under section 319 of CRPC. So accordingly, the section 319 petition filed by the APP was granted, my lord. My lord, the fact is that, my lord, the wife victim filed a 498 case before the police station, and the case was registered under section 498A, 307 and 34 of IPC, my lord. After investigation, the police has filed the charge sheet against the husband only under section 498A of IPC, my lord. And thereafter, the charge was framed, my lord. Kindly see the charge framing order, my lord, at page 38. Page 38, my lord. On perusal of case record, prima facie materials found against the accused person to frame charge under section 498A of IPC is found. Accordingly, charge under section 498A is framed against the accused Toyob Raj Borbhuya, as the case was, the charge sheet was filed under section 498A, my lord. Thereafter, my lord, the evidence was called for. The victim came and she was examined as PW1. Her statement at page 39, my lord. Her statement is required to read, my lord. May I read, my lord? I am the informant of the case. I lodged this case against the accused persons Talha Raj Borbhuya, Toyob Raj Borbhuya, Moinuddin Raj Borbhuya, and Saleh Raj Borbhuya. My lord, Toyob Raj Borbhuya is the husband, Moinuddin Raj Borbhuya and Talha Raj Borbhuya is the brother-in-law and father-in-law, my lord. And Saleh Raj Borbhuya is the mother-in-law, my lord. On the today, the one accused, Toyob Raj Borbhuya, is present in the dock today. In the year 2015, my marriage was registered with the accused, Toyob Raj Borbhuya, accordingly to Muslim law, and one kabinnama was also prepared. At that time, I was student and studying at my parental house. The father of the accused, Moinuddin Raj Borbhuya, demanded valuable furniture and one Wagoner car. However, my parents were not agreed to the demand of the father of the accused, but ultimately one Wagoner car was given to the accused, Toyob Raj Borbhuya. In the year 2016, after returning from Saudi Arab, the accused Toyob Raj Borbhuya, I went to my matrimonial house. Thereafter, the accused person demanded rupees 50,000 in lieu of clothes and gifts for the relatives. Accordingly, I informed my mother about the demand of the accused persons, and my parents did not agree to the said demand. As a result of which, the accused persons started torturing me mentally. They also told me that if I had to stay there peacefully, I would have to fulfill all their demands. The father of the accused, Toyob Raj Borbhuya, also forced me to transfer the ownership of his name of the plot of land measuring 3 kathas, which was in my name, in the name of my mother. My mother did not agree with the proposal of the transfer in the name of the accused's father, but she agreed to transfer the property in my name. My mother also transferred the ownership of the
Okay,
said land.
it seems that, yes, Gusami, it seems that there are. The court, I do not find any
Yes, ma'am.
illegality in the order. It is rightly
Yeah,
penned
rightly
order.
passed.
And everything has been discussed, and
Discussed.
why 319
Yes,
was,
ma'am. Every
has to
ma'am,
be
materials
implicate,
all
and
discussed, my lord.
complied with, everything is discussed.
319, court has the power, man.
Court
My
has
lord.
the power, and she also submitted that how the Talhazras
Yes, Talhaz,
assaulted her
everybody has assaulted.
very badly,
Badly.
his father, so
Yes. Yes.
any legality. However, if you want
Only
that,
notice may go.
only notice make.
My lord, one thing is
Otherwise,
here,
my-
my lord. It is,
Nice order has been passed by the learned court.
my lord, it
No
is true that
illegality.
the court has the ample power under section 392 to
illegality
call
has
the accused persons.
Hmm.
But there is a limit and ambit, my lord. There should be a parameter to use to pass an order under section
order has been
319, my
passed-
lord.
Order has been passed within the limit only. Very nice order has been passed.
My lord, in the prima facie of the case, my lord, her statement is contradictory, my lord.
Prima facie, it reveals that these are the accused persons.
May I submit, my
Hard
lord, one
Mr.
judgment, my
AKL
lord?
here.
May I
Hard
submit
Mr.
one
AKL.
judgment?
No
It
need.
is the
Hard
constitution
Mr.
bench
AKL
judgment, my
has
lord.
the learned court.
Where there is, the Supreme Court has says the parameter of the section 319, my lord.
That will be looked after into. This is not a case of pushing
But
and this is a
till
prima
that, my
facie
lord,
order, right? This
my prayer is that, my lord,
consider later on. No stay order will be there. Hard Mr. AKL that the learned consumptive petition. So it's for you. Issue notice. Issue notice to the respondent. Okay, same order. Here. So it also call for discard of this year. Distributable within it. Matter may be listed. So her cross examination is deferred.
my lord, her cross examination is happening. My prayer was that, my lord, the case may be proceed against the husband. And after some proceed, my lord, they
Then
may be
same
called.
exercise will
Thereafter.
be repeated exercise have to be done by the learned trial court below.
No.
Your petition, your husband will continue, then again your father-in-law and brother-in-law will continue. Repeated exercise has to be there. That should not be.
Your notice
Try to
issued.
dispose of the matter.
Notice issued, my lord.
Yes, no.
Abolish.
Yeah, please, Your Lordship. Okay, small prayer for expedition of the trial, Lordship. The impugned order is at page 32. Lordship, we have filed a criminal complaint. The case was first listed on 21 July 2025. In that order, Lordship, notice was issued upon the accused person. And the next date is given is 10/12. That is after 6 months. That's where I am offended, Lordship. This 6 months duration should not be given between 2 days. At least a
6
logic.
months.
6 months, Lordship. The order is at
Where
page
the
32.
case is pending in which place?
Lordship, Guwahati only.
Guwahati.
Guwahati, Lordship.
No, obviously, there are high pendency in Guwahati,
pendency, Lordship.
these are the high pendency, but still 6 months is.
6 months.
That may be the reason, my lord. But otherwise, my lord, it is a long.
To high pendency most probably, but
Yes.
still, I do agree that 6 months is quite a long.
Quite a long time, Lordship.
Quite a long.
But order is at page 32, Lordship.
Now, see, at best, the preponement of the date cannot be, at present, it may not be.
But if
good also,
direction may be given,
may not-
let the
but
magistrate.
direction may be obviously given, so that by fixing the next date. there
We
may
cannot
be
fix the next
options.
date here, but let a direction be given to the magistrate. He can fix the next date before. At least to some logical date, Lordship. Some reason time has to be given between 2 dates.
Order was on 21/7.
7/25. And the next date was 10/12, 10/12/25.
For filing this petition, have you made any prayer before the court? No. Before the learned trial court?
No, Lordship, because they don't have the power to recall once the date is fixed.
That is okay.
If a direction may be given to consider if possible on the part of the magistrate.
Yes, Sharma.
Well, really there is no such law, my lord. My lord, it is the number of cases, my lord, that determine, my lord. And I know, my lord, one thing, my lord, now will cases, my lord, identified by the color, my lord. Some, my lord, red color.
This
Red
is
color means, my lord, within the, my lord, 15 days.
dangerous.
Yes, dangerous. That is old case, my lord.
Yes, it's obviously.
Now that provision is also came, my lord.
There we had several meeting and all this for
Yes,
this
ma'am.
where the regarding the code management and how to case manage.
Yes.
And
How to
that if
dispose,
out
yes.
of the case
All
management, there are
pending
some
cases, my
categories.
lord. Priority is there, my lord, there. All pending cases.
Also overburden, I do agree. Especially the Kamrup Metro,
Yes, my lord.
Richard, Karimganj,
All
Bordra,
cases.
Hailakandi, these are overburden.
Silchar, Hailakandi, Nagaon, particularly.
Nagaon.
My main apprehension is, Lordship, there are 13 accused persons, and for service only, it will take more than 2.5 years. If such long dates are to be given. For service only, Lordship.
So now at this stage for appearance, for the hearing of, as per new
As per
BNS.
new BNS, Lordship. And I have not taken the steps for service upon the.
But this opportunity of hearing, if the opportunity is to be given to all the accused person, then obviously it will take some time.
It will take some time, Lordship. It will take some time because the first.
now,
How many your
13
petitioner?
13 accused, Lordship. So obviously, it will
From
take
our,
some
from
time.
same village, same locality.
Lordship, yes, Guwahati, Amingaon,
Guwahati.
containing districts.
Complaint, yes. Criminal complaint.
Your Mr.
People.
Hard Mr. King. So hard Mr. B. Sharma, the running petition paying on behalf of Mr. Respondent. This is an application by right now, the 28 BNSS. Being for washing and setting aside of the order date 21/07/2025. Passed in is CR case number 301 of 2025 by the learned GMFC Kamrup M. Guwahati. It is submitted by Mr. Kakoti that the order of 21/01/2025 was passed, whereby the case was fixed for hearing under provision of 223(1) subsection 1 BNSS, and next it is fixed on that only and so and so. Thus, between the duration as the next date of listing is about 5 months. Thus, the order passed by the learned faculty below, dated 21/06/2025, is discouraging and without assigning any reasons. The matter has been fixed for hearing under section 2231, section 1 BNSS about 5 months later without any justifiable ground. Accordingly, it is submitted by Mr. Koti that there are there are certain numbers of accused persons, and service of notice to all of them would require some time. And if shorter dates have been fixed, then the issue of service of notice on all the 13 numbers of accused persons would have been effected by established laws of the means. But fixing a date within with a gap of 5 months will delay the entire proceeding, will delay the entire proceeding, and for which present petition has been filed, seeking quashing of the order dated 21/07/2025 and praying for preponement of the next date of hearing, reasonably shorter date, and to pass any order or orders. Next part, Mr. Sharma, the learned additional PP submitted in this regard that the Kamrup Metro has the high rate of pendency in every court, and that may be the reason why the date is given within a gap of 4 of the 5 months, and moreover, for service of notice upon the 13 numbers of accused persons will also take a reasonable time. Mr. Sharma accordingly submitted that there may not be any preponement of the order. However, direction may be given to the learned trial court below to fix reasonable dates for completion of trial within a short. Next para, hearing this submission made by learned counsel for both sides, considering all aspects of the case, it is seen that the probability of giving a longer date may be so it is seen that the probable cause of giving longer date may be the high pendency of in the court. And it is also known that Kamrup Metro and some other districts of Assam has a high rate of pendency, and it may be one of the reasons for giving such longer date. But in the same time, it also cannot be denied that such a long date may also affect the disposal of the case, and it may not be disposed within a reasonable period. So considering all these aspects of the case without interfering the order dated 21/07, so the learned trial court below is hereby directed to consider the matter and to fix preferably a shorter date from next day onwards, so that the matter may be disposed of or may be disposed of within a reasonable period with the above observation. Okay, we are giving a direction to give a shorter date since I just want to say one thing. We are rising at 3:15.
Yeah.
So there may be some matters may not reach also. So if you have some marketing matters that it may be placed at what? Just after 5 minutes.
So let's say item number 26, my lord, is a statutory appeal, my lord. Simply notice will go, my lord. 26. My lord. IA is also is there. That will be considered after the LCR, my lord. Item 26, my lord.
26.
My lord. 26. Under POXO, my lord.
Box.
POXO.
Box. Statutory approval. I noticed against the order of police patient. Side of work. Issue notice.
Informed.
And here, Mr. Koshi, here also, to jurisdiction, police station better to set or to rest. Because it is the case of. No, that is that procedure only we can send, na? Yes. We done it. To jurisdiction, police station, rotate to the office of the district prosecutor. Okay. Actually, go go on. Please. You take state, we listing after 4.
My lord, after a week,
After 4 weeks.
4 weeks. My lord, and IA is for consideration of bill that will consider after LCR.
This will pass according.
My lord.
Please, your lordship. If I beg to mention. Lordship, I beg to mention item 30 and 31. And seeking reduction of bail amount, I mean custody for 625 days. So I'm praying it may be taken up today. 30 and 31.
So what are you saying? 30, 31, yes?
I'm seeking reduction in my bail amount.
No, we are not going to hear. If you have any adjournment pay, that can also be considered. So here,
For upgrade.
pardon?
If it may be taken up, lordship, for upgrade.
No, if it reaches only, then only.
Okay,
Otherwise, we
okay.
cannot. One just announce it because 315 it may court will be rising. That's why I thought that if there is. It reaches, it will.
In item number 41, and Lordship, there is a delay of 49 days in preparing the revision petition. Lordship, the notice may be issued, Lordship. 41, Lordship. There is a delay of 49 days in preparing the revision petition.
49 days.
49 days, Lordship.
I is for condemnation.
For condemnation.
41 to Kali notice. The this one number listed 80 and listed. List after 4 weeks. 4 weeks will do?
Yes, sir. Oblige, Lordship. May I please answer? Lordship, in item number 39, I is there, my lord, for condoning the delay of 72 days. State is the formal party, my lord.
Notice will go?
State is the formal party, my lord. No.
Only state is there.
Yes.
Any other?
No. So, I may be condoned, my lord. Delay may be.
We are not going to hear. We are just saying that if any adjournment prayer is there, if it reaches, then we'll hear. Otherwise, no hearing. Don't make it confident.
My lord, item number 32, my lord. Today is fixed for my lord, bail application number 1590 of 2025.
32.
Yes, my lord.
Now see, bail hearing is, what is the position here? Bail hearing, 32. 32 is fixed, what is the position? Scan copy received.
Scan copy received. Adjourn না কৰিব
Adjourn না কৰিব মই
কৰিব যদি আহিব
I number 2 icon.
I'm not understanding.
Now I cannot say at this stage whether it will reach or not. If it will reach, then we'll hear it. If it doesn't, then it may not reach. That's what only I'm saying. If any adjournment prayer is, then you can make.
No, Your Honor.
No, if it reaches, then we'll take it up. If it doesn't reach, then it's okay.
May it please your lordship.
Yes.
Lordship, this is a matter where there is a civil suit pending in between the parties, that is the present petitioner and the respondent number 2. There is also a criminal case, your lordship, filed by the respondent number 2 against the present petitioner. So facts are like this, your lordship. I am the owner of a plot of land and respondent number 1 wanted to purchase. So there was an agreement for sale, your lordship. The consideration was fixed at rupees
5.75 crores. So out of that, your lordship, on the first date of the agreement, he paid 5 lakhs and thereafter he did not pay anything. Now he is demanding, your lordship, that he has paid more, and that is a disputed amount, your lordship, that he has paid 2 crores 71. Even then, your lordship, he is to pay balance 3 crores 30 lakhs, your lordship. He is to pay. So I insisted that unless you pay the entire amount, then I will not execute the sale deed. I will not apply for permission also. That is the case, your lordship. Now he has filed a criminal case also, your lordship. Now the Supreme Court has repeatedly said when the matter is in the session of the civil court, the criminal case, proceeding of the criminal case
In
is
civil
an abuse
court,
of
who filed the civil suit?
lordship.
Civil suit, who filed the civil suit? You or by the
So civil case filed by the respondent number
respondent?
2, your lordship, and he has filed a criminal case also against me. I am the owner of the land. Unless I get, your lordship, the entire amount of the consideration, I am not bound under the Transfer of Property Act to execute it in sale deed. Simple matter, your lordship. At this stage, my only prayer is, your lordship, matter may be admitted and records may be called for. Whether actually this criminal case can proceed, your lordship, in view of the pendency of this civil suit.
So what is the stage of the case? Is charge
Lordship.
sheeted case? Not yet charge sheeted.
Lordship.
Is it case is charge sheeted already?
No, succeeded, your lordship, and the court had also proposed to frame a charge. As against that, I have come here.
My lord, basically, my lord, prisoners challenge, my lord, the order is the 26-25, my lord. There is a details order, my lord. My lord, may come to page, my lord, 121, my lord, the last part. So, my lord, they elaborately, my lord, they discuss the some Supreme Court decision also, my lord, discuss, my lord. Apparently, my lord, there is, because, my lord, they have received the, my lord, advance amount as well, my lord, 2 crores 71 lakhs. Thereafter, my lord, even
What is the
thereafter,
order about? What is
My
the
lord-
order? What is
my-
the order in fact?
yes.
Order is for what?
Order is for, my lord, the next date is fixed for, my lord, kindly come to 122, my lord, last, accordingly fixing the next date for framing of charges. Charge is not yet framed, my lord, but it is the,
Proposed to
yes, my lord, proposed to
frame charge.
frame charges, my lord. And my lord, the law of, my lord, framing charges, it is discussed, my lord, in this,
So as
this
against
order.
that, your lordship, matter was exceptionally hard for 3-4 days, your lordship. Thereafter, the court kept it control that there is, according to me, there is, I can presume that there is ground for framing charge. So whatever decision we put before the court, your lordship, not a single decision has been discussed, and your lordship will find whatever is the allegation in the complaint petition, that is the allegation in the plaint also, your lordship. So the law says, your lordship, our High Court and the Supreme Court, your lordship, this is your remedy that for specific performance of the contract. He has filed the suit for that purpose. Now, if he gets the land and I get the balance upon, your lordship, matter is solved, your lordship. Instead of that, your lordship, he has, you want to penalize me, your lordship, under the cloak, your
So
lordship.
is there any interim prayer for you?
Lordship.
Previous saying stealing notice. Is there any interim prayer for you? You prayed for any interim relief now?
Lordship,
Whether you are praying for any interim relief here?
lordship, I have prayed, your lordship, interim prayer.
For against disorder, for
Lordship,
stay?
against your lordship, this is a limited question, your lordship. Whether a criminal case can proceed, your lordship, in view of the pendency of a civil suit having
That's
the
what-
same subject matter.
That's what, but if you go by the order, that is
Lordship.
in 2006-2000.
Now, if your lordship will go by order, your lordship.
There's an elaborate discussion.
Yes.
No,
elaborate-
elaborate decision only on factual position, your lordship.
Okay.
But I have annexed the deposition of the witnesses, your lordship, recorded under 161. Not a single witness have stated that I have cheated him, your lordship. Only their statement is there, your lordship. You can go to your lordship. I am just placing. I am just placing, your lordship, their statement, 7 series, your lordship. Annexure 7. At page 96.
Their portion is in, my lord, 21. Yes.
21.
Now, your lordship will come to page 96, your lordship. A statement of Sri Simonto Hoikia, 21st son of Soncho. My name and address as aforesaid is true. I am 24 years old. I have been working as a security guard in the Vasudev Commercial Complex under the Lokeshwar Bura, that is the petitioner, since 3.5 years. Lokeshwar Bura has his office in the 4th floor of this complex, but he has not come here since few days. Instead of him, his wife used to come here in times. I do not know anything more than this. This is all that I have to say. Is there any criminal, your lordship, any whisper that he has made out any criminal case, your lordship? Similar is the statement of Sri Gudu Soikia, your lordship. Same statement, your lordship, I am coming. My name and address as aforesaid is true. I am 22 years old. I have been working as a security guard in the Vasudev complex under Lokeshwar Burwa since 1.5 years. Lokeshwar Burwa has his office in his complex itself, and he has often come here. But since few days, he has neither come to his office nor to his place. I do not know anything more than that. Then what offense has been made out, your lordship? Out of these two witnesses, your lordship, what evidence, from this evidence, what offense can be made out, your lordship? Nothing. Now you will come. This Rajesh Kumar Jalan, your lordship, kindly skip. 4, your lordship, will come. Next page, your lordship, therefore, Amit Kumar Prasad, your lordship. My name and address as aforesaid is true. I am 48 years of old. I am presently working as a retainer of Rajesh Kumar Jalan, that is the respondent number 2 here. I come to Guwahati back in the year 2010. I signed the agreement as witness, which was executed on 34/2010. That is the agreement for sale, your lordship. I did not know anything about the transaction between Lokeshwar Burwa and Jalan. He does not know, but they both were present when I signed the document as witness. Burwa signed willingly. On 24/1/2013, I gave Burwa rupees 5 lakhs, which was as was instructed by Rajesh Kumar Jalan. Since Lokeshwar Burwa was not in office in Christian Bosti, therefore I went to Hotel Ambaris Ganeshguri to give him the money, and he signed the money receipt. This is all that I have to say. So what offense has been made out, your lordship? He came to me, your lordship, with 5 lakhs rupees. It is handed over to me because that is my installment to get as a balance. Now your lordship will come.
Okay, I have gone through.
Witness number 5.
Okay,
Some
Mr. Ali, I have
Azimuddin
seen.
Ahmed.
Okay, I'll pass.
Bye.
Heard Mr. S. Ali Vidyanan counsel for the petition. And also heard Mr. B. Sharma, Vidyanan petition, appearing on behalf of state respondent. This is an application and section swings in connection with challenging the order date. Assignment. Last order. So passed by JMFC M, whereby the case was fit for consideration of charge. Issue notice to the respondent to registered AD, and as usual process, no formal notice is required to be served. State respondent number 1 also called for stamp of the PLC. Expert heard on the interim relief. Expert is submitted by Mr. Ali that the present petitioner is innocent, has not committed any such offense as allegedly applied. It is an admitted fact that one civil suit is pending before. Civil suit is pending before which court? Civil suit is pending before. Civil just 2. Civil just senior division. Civil just 2 senior division. Kamrup and Guwahati. And it is basically a civil dispute wherein the agreement for sale was executed by the present petitioner in favor of the respondent number 2 for proposing to sell a plot of land. further submitted that without considering this aspect of the case, and also even considering, and it also without considering the judgment and the materials placed by the petitioner, the order has been passed by the learned JMFC, and for which the JMFC. And accordingly, it is submitted by Mr. Ali that further proceeding may be stayed till disposal of this. Next para, Mr. Sharma, the learned Mr. will be raised objection and submitted that there may be a civil dispute between the parties, but there are the allegation of cheating brought by the respondent number 2, and accordingly, the learned trial court below made an elaborate discussion and passed the order accordingly. Next para, hearing the submission made by learning counsel and considering all annexures filed along with the petition, the aspects of the case, the further proceeding in case number so and so pending before the court of learned GMFC so and so against the present petitioner be stayed till next day. Please the matter according. Okay, it will be stay will be operating, and you take
Mr.
steps
Record
for-
may call for your lord.
Yes, we are called. Take steps on the respondent number 2 and matter is stayed.
May I please, your lordship, the question petition lordship against the complaint case filed by the wife of the petitioner lordship. The wife filed the 5 cases lordship. The initial summon lordship, the kindly the page number 27 lordship. That is the summon issued by the chief judicial magistrate to the petitioner to the Merman lordship under section 498A, 494.
Wife lost the case.
Lordship,
Wife lost the case.
oh,
Wife lost the case.
lordship, lordship,
Then
the lordship, that is the first initial case lordship. It was summoned to the accused petitioner lordship. Thereafter, lordship, the wife of the petitioner filed the complaint case against again lordship. The page number 28 lordship and except for lordship. That the same allegation on the 494 lordship complaint case. That case has been disposed of by the order dated lordship, page 34 lordship. Page 34 lordship, that is dismissed for default due to the non-appearance of the complainant. Thereafter, lordship, there was.
then it was not
filed-
disposed on merit.
No, not married, Lord, no. Thereafter, lordship, wife filed again complaint case under 125 CRPC for maintenance lordship. That case is already disposed of with the maintenance amounting 13,000 rupees. Now it is enhanced for 4,500 lordship. Thereafter, lordship, the wife filed again the DV case under section 12 of the Protection of Women from Domestic Violence Act, lordship, 2025. Now, lordship, the wife again filed the complaint case, filed complaint case number 15 of 2025 under section 82(1) of the BNS Act, lordship. That lordship, the 494 offenses already cognizance lordship by the initial case filed by the petitioner lordship. That is lordship, the page 27 lordship.
that the other case which was disposed of earlier 494 IPC,
That is not, Lordship,
that is already disposed of. You got acquittal.
Lordship,
You got acquittal there.
no, Lordship, on 494 who is on file, but the wife, that is,
No, no, 494, the earlier also one 494 was filed.
file.
Then what is the position of that case?
That is disposal on the default of.
Only on
Anarchy.
default, not on merit.
Not on merit. But 494 offense is already cognizance by the Chief Judicial Magistrate Boinga Lordship.
Now see,
That is the-
cognizance is
Okay.
one part,
Okay.
but that was not disposed on merit.
Lordship, not,
So merit of the case was not considered.
not,
Only for the absence of the complainant or his on her default only, the case was disposed of.
Lordship, I have not that ground, Lordship, but the initial case was on file, the FIR by the wife, Lordship, under section 498A and 494, that proceeding is already has taken against the petitioner.
It is still pending.
Lordship, it is pending.
So you have not annexed this one, that one.
Lordship, I have only annexed the summon, Lordship,
No, no, just
page
confusing.
27.
Now the present petition is a complaint case or a government?
Complaint case.
A complaint.
Complaint case, 2025 was on the file,
This is the complaint case.
complaint case.
And earlier 498 and 494 is still pending.
Lordship.
So you
Pending.
summon in which case?
I came against the Lordship.
In the present case,
Present case.
this complaint case, you
Com-
received this summon.
Complaint case, Lordship. The complaint case number 15 of the 2025. Lordship.
In that case, you are receiving summon.
Some
And where is the order of the other case? Is there any order that the other FIR?
other FIR, Lordship, the already stated by your Lordship is order, Lordship. This is Lordship order.
So you want to, in that case also case has already been charged.
Oh, Lord, already, sir.
Yes.
Already.
When they got charged, then again with this similar allegation, this.
Similar resolution, Lordship.
State is a formal party. There may be DB 125, but your main contention is that in the at it even in during the pendency of
Pen-
that affair, same with the
Same,
same
same
allegation.
case has been already filed, Lordship, again. The repeated exercise, Lordship.
You are Mr.
DC Nath.
Private study, see that. But. We shall for the other election. The application. Washing sweats. The response, no formal notice is required to be served. Response number one, state response number one. However, copy of the petition may be submitted. Also call for the scan copies. Next, it is submitted by Mr. Nath that the present accused petitioner is that's not such copies as well as in the present FIR, present complaint. He further submitted that the respondent earlier lodged a complaint which was registered in section 494 IPC, wherein the accused petitioner got acquitted, and thereafter she lodged a case under DP Act as well as a case in section 1 with FCRPC seeking maintenance. Thereafter, Further, she lost another FIR, which was registered under section 494 and 498 IPC, which is still pending. But suppressing the penalty of the earlier FIR, the present complaint has been lodged with the same set of allegation and which has been registered under section 82(1), 5, 115(2), 351(2), 351(2) and 3. And object 3 subsection 5 of the BNS. And if cognizance has already been taken,
Lordship, already.
and cognizance has already been taken, the present petitioner had received a summons in connection with this case. According to Mr. Nath submitted that the further proceeding of the present case may be stayed till the disposal of this. Considering the facts and circumstances of this case, and also considering the fact of pendency of the other case, the further proceeding in the present case is stayed till next accordingly. Okay.
Lord.
Take steps for respondent number 2.
Respondent number. Problem.
May I please, Your Lordship? Lord, this application is under section 528 of BNSS. Recalling of your Lordship, PNA and non-bailable warrant of arrest against the accused petitioner in connection with Sessions case number 52 of the 2015 under section 36665. Your Lordship, the FIR is at page number 19, Your Lordship. The page is the page number 19. The vernacular.
অতি মাননীয় মায়ং আৰক্ষী এই নিবেদনৰ ভাৰপ্ৰাপ্ত মহোদয়ৰ সমীপেষু বিষয় এজাহাৰকাৰী শ্ৰী সাগৰী বিশ্বাস, স্বামী শ্ৰী শম্ভু বিশ্বাস, হাতীভাঙি, থানা মায়ং, জিলা মৰিগাঁও। নিবেদন এই যে যোৱা ইংৰাজী 7/12/2014 তাৰিখে ৰবিবাৰে মোৰ ছোৱালী শ্ৰীমতী বাটাচী বিশ্বাস হাতীভাঙিৰ অষ্টপ্ৰহৰ 1 নাম চাই থকা অৱস্থাত সন্ধিয়া প্ৰায় 6-7 মান বজাত এজন অচিনাকি ল'ৰাই অপহৰণ কৰি নি বৰ্তমানে আমি গম পাইছো যে ডিপ্ৰাং বজাৰৰ ওচৰৰ মানুহ এঘৰত ৰৈ আছে। ছোৱালীজনীৰ বয়স 14 বছৰ। গতিকে মহোদয় উক্ত ছোৱালীজনীৰ দুয়োকে ধৰাই আনি উক্ত ল'ৰাজনৰ ওপৰত বিহিত ব্যৱস্থা ল'বলৈ এজাহাৰ কৰিলে।
Accordingly, the Mayang police station arrested the accused petitioner as well as they recovered the victim in connection with this case, that Bakasi বিশ্বাস, Your Lordship.
And now, my lord, kindly peruse the page number 106 and 106.
It is the 164 statement of the victim, Your Lordship. Kindly peruse the 106 page number.
My name is Batasi বিশ্বাস Swainso. মোৰ নাম আৰু ঠিকনা ওপৰত লিখা ধৰণে হয়। মোৰ বয়স 20 বছৰ। আসামী মতিৰামক মই যোৱা এবছৰ ধৰি চিনি পাওঁ। মোৰ ঘৰৰ লগত মতিৰামৰ মাৰ ঘৰ। মই আসামী মতিৰামক ভাল পাওঁ। মই মতিৰামক ভাল পাওঁ আৰু প্ৰেম কৰোঁ। কাৰণে আজিৰে পৰা 4 দিন আগত মই মতিৰামৰ লগত নিজ ইচ্ছাই পলাই যাওঁ আৰু তাৰ লগত পলাই তাৰ মাহীৰ ঘৰলৈ যাওঁ। তাৰ মাহীৰ ঘৰ ডিফ্ৰাঙত। মই 4 দিন আগতে মোৰ ঘৰৰ ওচৰত লগা মেলা চাবলৈ গৈছিলোঁ। তাতে মই মতিৰামক মাতি তাৰ লগত পলাই যাওঁ। মই মতিৰামক ভাল পাওঁ কাৰণে তাৰ লগত গৈছোঁ। মতিৰামে মোক ফোৰ্সফুলি নিয়া নাই। মই মতিৰামৰ লগত বিয়া পাতিব বিচাৰোঁ। মোৰ ক'ব লগা এইখিনি।
Your Lordship, accordingly, the police also send the victim to the medical examination. Accordingly, in the said medical examination also, there was no any physical relationship between the parties.
Okay, these are the facts of the case.
Yes, Lordship.
I can understand that there may not be, the allegation may not be against such a grave or whatever she has made a statement in favor of the accused.
Yes, Lordship.
But what is the conduct of the accused? Now the case is not, what is the conduct of the accused? That the court had to issue PNA and all. That
Yes,
has to be
Lordship.
seen. Yes,
It is
why?
the fact that, Your Lordship, he was a defaulter to appear in connection with this case. However, initially when the matter was taken cognizance by the Lane Additional District and Sessions Judge Morigaon,
on 2 dates he appeared there. However, the statements of the victim itself reveal that she voluntarily eloped with the said accused petitioner. And at the time of evidence, he thought that the said victim girl would come to the honorable court and she deposed her evidence in connection with this case. However, immediately after recovering the said victim girl, the parents of the victim girl marry her to another person. Accordingly, she never come to the honorable court for her evidence part. And most important thing is that, Your Lordship, it is a fact that he is also defaulter, that he failed to appear in connection with this case for the last 10 years. But right now, Your Lordship, he wants to appear in connection with this case. But the thing is that, my lord, one PNA and NBW issued against him. But the thing is that, my lord, if the whole facts is that she voluntarily stated that she eloped with her, so my lord, at least give him a chance to appear in connection with this case by recalling the said NBW and PNA.
So when the first NBW was issued, as per you have annexed some order.
Yes. I'm annexed. It
Because it seems
Order
that
part-
DNA, yes.
order part started from page number 50.
Hmm. So initially he was on bail and then case was,
Yes, for
Uh,
fixing
this-
for PWs.
yes, and then it was fixed for PWs also.
Yes, Lordship. Continuously, it was fixed for PWs.
Mm.
But the thing is that, my lord, he left the place and went to his native place at Rajasthan. Thereafter, he never come. However, when the PNA and the NBW issued against him and the concerned police station of Rajasthan and issued him.
He is
came-
from Rajasthan.
Yes, Lordship. His maternal uncle's house at Mayong at Morigaon, Your Lordship. My lord, at this initials, my lord, his prayer is that at least give him a chance to contest this case.
But conduct is very bad, my lord. Initially, my lord, on only two occasions he appeared, and thereafter, my lord, he disappeared completely, my lord. And
For
he
last 10 years. For last 10 years.
last
Yes,
10 years.
It's a fact that he failed to appear. But the thing is that, my lord,
He
if
intentionally
the victim's statement, whatever the victim stated in her 164 statement, reveals, Your Lordship, that there is no any case against him, Your Lordship. So, my lord, at least given him a
That
chance
will
to
be in the
contest.
trial, my lord. That will come in the trial, my lord.
That is why, Your Lordship, he wants to face the trial.
But Mr. H.D. Roy didn't cross the petition. So her petition not done in the It's an application. It is submitted, Mr. Roy, that the present accused petitioner is innocent and he is not committed such offense as there is in the also from the statement of the victim recorded under section 1 CRPC also reveals that she voluntarily eloped with the present petitioner and out of 11 efforts. However, after case being charged, the accused petitioner was appearing before the learned trial court below, and case was also fixed for evidence. But even after several days, the victim did not appear before the court to adduce her evidence. And from the reliable sources, it was learned that she got married in another place, for which she divorced. In the meantime, the accused petitioner had to leave had to left for his native place at Rajasthan, and as he did not had any communication with his counsel, he could not appear before the learned trial court below, and for which the NBW was issued against him, and subsequently your case is also filed. Last order.
Yes. It was a last on 5/8/2025, Your Lordship, and the matter is fixed now on 31/10/2025 for appearance. It is at page number 97 in my petition.
Acha. The, it's but subsequently, and as the NDWA could not be executed, the learned session judge had issued PNA against the present petition. However, coming to know about the present circumstances of this case, the accused petitioner is ready and willing to appear before the learned session judge and to contest the case accordingly, if he is provided with some interim protection. Next para, Mr. Sharma, the learned PP submitted in this document that after the case being charge sheeted, the accused petitioner appeared in 2-3 occasions before this court, and thereafter he absconded since 2015. And considering his long absence, the learned session judge had to issue NBWA against the present petition. So considering the conduct of the accused petition, his prayer may not be considered at this stage. Next, after hearing the submission made by learned counsel says, I have also perused the case record and the annexures filed along with the petition, especially the order sheets. It is an admitted fact that after filing of the charge, the accused petitioner was appearing for some occasion, but thereafter he remained absent for a considerable period, and the NBWA was issued against him since 2015, and finally, in the year 2019, the PNA was issued against the present petition. Thus, it is seen that the learned court below had took all endeavor to procure the attendance of the accused petition, but since last 10 years, the accused is absconded, and which also delayed its proceeding. Considering all these aspects of the case and the conduct of the accused petitioner, I do not find any reason to pass any order on order of interim protection of the accused petitioner. However, the petitioner is at liberty to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with. Accordingly, I do not find any illegality or irregularity committed by the learned court below in passing the orders. Accordingly, the present petition stands accordingly disposed of. We cannot provide any interim protection to you. Rather, only we are in the order I have reflected every submission made by you.
Yes,
that on the what basis he was not appearing on the. But it is not a case of any interim protection.
My lord, at least give him a chance.
It cannot be. Last 10 years he is absconded.
Yes. Much of it.
Disposed.
May I please, Lordship? So this
14 along with
45. In both these cases, Lordship, this petitioner is also same and the respondents are also same, Lordship. Yeah, this case is that, Lordship, this petitioner, who is the brother-in-law of respondent number 2, and in this case, respondent only, sole respondent, and in next item, respondent 2, she has, Lordship, lost different cases against the entire family members of this petitioner. So that's, Lordship, I have annexed the document at page 14 is the first copy, Lordship. This is an application under section 12 of domestic violence, Lordship. The same fact, Lordship, she has lost in different courts. First in page 14 is a petition of under section 12 of Domestic Violence Act. And Lordship also initiated proceeding under section 85. Apparently, Lordship, there is no bar to proceed simultaneously in section 12 and 85. However, the fact remains that whether Lordship the release sought for in bodies proceeding and the contents of bodies proceeding are same or not. The contents of bodies proceeding are same. That cannot be Lordship initiated, which Lordship violated Article 20 of the Constitution of India. Now, Lordship will find the contents of page 14. This is the petition under section 12. Exactly same in the petition of Lordship, the page number 36, filed under section 85. Whereas Lordship, this petitioner, he stays at Lordship Nalbai town separately. Only he is the brother of this Lordship, the main accused. Main accused means the husband of the husband of Lordship. Now, Lordship, if Lordship allow me to read the petition, entire petition. So I can read the Lordship. Lordship will find no Lordship ingredients to attract the provision of section 85. Section 85 and the Lordship to consider the offense under section 85 and the offense to under 12 is completely different. Here, Lordship slightly Lordship can take cognizance under section 12 because there may be some abusing or like Lordship teasing, and that may be there. Their allegation is also there. But section 85 is completely different, Lordship. So if Lordship allow me to read this petition to what is two petition, I will read it, Lordship. Lordship will find whether there is any ingredients to Lordship the initiate a proceeding under section 85 of this BNS Act.
But this criminal petition, I mean, item number 14 is for
I think number is
of
domestic
DV.
violence. The only, and next one is Lordship for this 85. Item 45 is 85. That is there for Lordship. Yesterday it was listed, so I take up
Acha, this item number 14 is for DV
DV.
and 45 is for 85.
85. So Lordship, this petitioner who is residing separately in Nalbai town, and they are residing at Patsala, away from Lordship, around 25 kilometers away from this place of occurrence. Now, being a Lordship, only because of this, he is the brother of her husband, and she has implicated all the family members, mother, father, and her sister, and this petitioner, brother. And this petitioner, Lordship, he is a young man who is also Lordship pursuing to be enrolled in the defense service. Now he has been got selected, Lordship, even in now Bhaiba is to be held in next month. Because of this, all this Lordship proceedings, he cannot file any affidavit stating that there is no criminal case pending against him. That is one first problem. And second problem, if Lordship goes DV, Lordship, I am not pressing on DV. DV may be initiated, and in DV proceeding, Lordship is a civil nature, Lordship. Even the counsel of this party can represent the proceeding, not necessary to be present by person individually. So in 85 proceeding, Lordship, there is no material settled to initiate 85 proceeding. However, Lordship, the trial court, without considering all those aspects, has Lordship, process has been issued, now case fixed for evidence before charge. And this petitioner is coming from Nalbari, Lordship, he is attending the court without any fault on his part, only because he is a family member of her husband. So at this stage, Lordship, notice may be issued. I am paying only for item number this 45, petition under section 85. There is no ingredients at all, Lordship, to attack the section 85. I can read the section Lordship 85 and the 86 definition. Nothing
Where
is
is the 85, I mean 85 is
It's really-
complaint, that is also a complaint case or government FIR was there?
complaint case.
This was also
Complaint case, both are
Both
complaint
both
case.
they are both,
Yes.
DV is to complaint obviously and
Yes.
other one is also.
Though both are complaints.
So where is the complaint of 85?
Yes.
85?
Here, Lordship will find at page 36 in item 14 itself,
85 is 36.
page 36. Same petition, Lordship.
Okay, same.
Only the section is different and the code number is different. Otherwise, everything is same. Paragraph
From
8,
where
the
you are saying
language,
that your petitioner is not at all implicated here? From the statement you're saying, there's no at all implication.
Lordship, it to attack the provision of 85. Page 36 is a petition, exactly same petition, which is Lordship filed in DV case also. And in 85 also, Lordship, she has claimed rupees 20 lakhs as compensation. So in 85 also same prayer, Lordship, 85, 2 lakhs she has claimed.
And in DP also lordship, she has claimed compensation as well as other protection under Article Section 18, 19, 20, 21. So that is why lordship, I'm saying at this stage, lordship, notice may be issued to this respondent number 2, and the proceeding under Section 85, let that may be lordship take. It is completely lordship, abuse of process of law, lordship, nothing more.
So your name is?
My name is lordship Juvraj Pathak. In response number 4, in board this petition. Response number 4, my name is at response number 4. And response number 1 is her husband, 2 is my mother, 3 is my sister, and 5 is my father. My name has been implicated in page number 22, lordship. Page number 22, my name has been implicated at response number 4. Paragraph number 13, page number 22. Yes, I am reading, lordship, the paragraph number 13. At page number 22, lordship, got it, page number 22. Yes. The aggrieved party states and submits that response number 4, respondent's brother, the response number 3, sister, always torture her mentally by saying good for nothing and never allowed to stay in the separate accommodation given for the bridal night where all her furniture and clothes were allowed to keep. The aggrieved party also not allowed to resell her own gold jewelry gifted at the time of marriage by her parents, relatives, and respondent sides. Response number 3, mother-in-law willfully take the custody of her gold jewelry and still those are in the custody of response number 3. The aggrieved party states that one day for her own requirement, she had asked to enter into her room, but the response number 3, mother-in-law never allowed her to enter. The response number 4, mother-in-law and response number 3 throws her chair and table for her for some known issues which is not satisfactory for them. For while the aggrieved party was mentally suffered in matrimonial home, as the response number 4, brother-in-law, and response number 3, sister-in-law, disrespect her as response number 3 of as their own brother's wife. Under such tedious situations, the aggrieved party's health again deteriorated to the level of no return, and she informed her father about her health condition. The father informed the response number 1. Accordingly, they hospitalized her and doctor informed her as she was suffering from anemia and low BP. This kinds of lordship allegation is there. So this kinds of allegation lordship cannot attract the provision of section 85. 85 is completely defined lordship, which is defined in 86. Just I am reading lordship section 85 and 86. Of lordship BNS Act 23. Husband or relative of husband of a woman subjecting her to cruelty. May read lordship. Whoever being the husband or the relatives of husband of a woman subjects such woman to cruelty shall be punished with imprisonment for a term which may extend to 3 years and also shall liable to fine. The cruelty defined section 86. Cruelty defined. For the purpose of this section, cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health of the woman. Harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security or is the amount of failure by her or any person related to her to meet such demand. Nothing is there lordship in this petition.
ধৰি লওক এটাটো খালি 45 40. Mr. Kalita, your name is not there?
Yes, in item 14, Lordship. By
You are
mistake, so my
appearing-
name is not there, but I am in there.
Appearing on behalf of or appearing?
Lordship, I am appearing.
Heard
In
that it
what
is
the cases?
rejected on constitution. But also heard. Sure. In 14 state is a formal party or is no formal? Not
No formal party, because in DV case, Lordship, state is not necessary.
No, no,
Lordship.
it's okay. No, just I'm asking.
Yes, I have not made party of state.
Oh. So it's issue notice. Issue notice to the respondent. Number respondent to registered AD as review process. Also for the SCAP of the TCR. This is matter for the afterwards. In item number 14, simple one. Come to item number 45. Hard say so and so. Get it was. I also heard Mr. E. Sharma, the land action paying on behalf of state. It's an application of the section sewage connection pursuant or for setting a second portion. The impel processing of CR case number 05 planning the learned CGM body in respect of issue notice. Same for the state and the notice to the respondents. However, no formal notice is required to be served on state respond number 1. And copy of the petition may be served during the course. Also called for the scan of the TCL. Next, third on interim relief. It is submitted by Mr. Kalita that the present petitioner is no bigger the alleged office. And the respondent number 2 had named all the family members of the husband of the respondent number 2 in both the in proceeding under section DB Act, and with the similar allegation present complaint has been lodged against the family members of the husband of the respondent. However, there is no such ingredients attract section 85 PNS against the present petition. And the allegation which has been brought against the present petitioner also does not fulfill the ingredients of section 85 PNS. Accordingly, he submitted that till disposal of the present petition. The further proceeding in respect of the present petition may be stayed. Expert hearing the submission made by the materials available in case record. The other aspects of the case. The further proceeding in CR case number 05 of 2024, pending before the learned CGM Norbury is state in respect of the present petition till the next date of listing. This is the matter according to
Lost. Deeply obliged.
Court is of opinion that the order of conviction and sentence is rightly passed by the learned additional session just some special justice judicial. And accordingly, the present appeal stands dismissed, and the judgment pronounced by the learned additional session judge is hereby up.
File.
Just Tiny.
Sorry, Lords.
You are.
This Lordship. But for 528 petition Lordship for recalling of the unbelievably acknowledged the PNA issued against the petitioner Lordship. So whatever Lordship in the year of 2021 Lordship, an affair was lost against the petitioner Lordship, and accordingly IU has submitted a search sheet Lordship, praying for declaring the petitioner as absconder Lordship.
That means he is charged as an absconder.
Absconder Lord. Therefore, accordingly, Lordship, after submission of the search sheet Lordship, the cognizance has been taken Lordship under section 366 of IPC Lordship. After taking cognizance, summons were issued Lordship. Those summons were issued, but the petitioner never received any summons from the trial court Lordship. Thereafter, Lordship, NPW has been issued Lordship. And accordingly, since the petitioner even failed to appear Lordship after issuing the NPW, after Lordship, the trial court issued the PNA Lordship. Actually, Lordship, he had no knowledge Lordship about the pendency of the present case Lordship. Cognizance was taken Lordship on 22 Lordship. And NBW was issued on 2022 Lordship. And subsequent to which, subsequent to that order Lordship. Lordship is ready to appear Lordship.
No, here nothing wrong in the order. Several location it has been sent and PNA has been issued by them.
Order of PNA order was passed.
Yes,
Yes, but PNA order passed. Indirectly is praying for anticipatory bail.
18-6.
Indirectly, it seems is
18-6
praying for
24.
anticipatory bail, because PNA is issued by law. You can go and the court will deal as per law.
Then Lordship, kindly have a look at the service report Lordship. I have annexed all the reports even Lordship. Lordship will find at page 17 line Lordship onwards Lordship.
Service report on several location, they went, he could not be traced manner, ultimately considering the long tendency of the matter, NPW was issued. There is nothing wrong in this.
No, I am saying, where is the order of issuance of PN?
By the page, annex 13, my lord.
Page?
Page 31 Lordship.
Yes,
31.
6465, NBW, and PNA.
31 Lordship, that is the first order of the NBW Lordship.
No, PNA order.
PNA. Lordship, PNA Lordship,
Page
that is
64.
page 64. Annex 13 Lordship.
So your plea that you have not received any summon
Yes.
and you were not aware of.
Not your even Lordship. Even Lordship has search sheet has been laid Lordship as showing the petitioner as absconder even Lordship. And if the Lordship will peruse the search sheet Lordship will imagine one thing Lordship. The search sheet is annexed here with Lordship. That is at page Lordship 25. I hope Lordship on the last part. Lordship.
Page, what have said?
Second, page 25. Lordship got it, Lordship. During investigation, I have made several attempts to apprehend the accused, but always found him unavailable at his phone. On 22/12/2021, 07/01/2022 and 23/01/22, I searched for the affair name accused so and so at his house at so and so, who is Sir Andrews herewith proceed.
So then
Lordship-
what police will do? He made several attempts.
What is
Several
wrong
attempts
there?
made. What
As-
is the
as-
fault on the part of the police?
Lordship, the affair lost on Lordship, when Lordship, it was lost on the 1/6/2021. 1/6/2021. When he visited Lordship, as per his statement, Lordship. Her September Lordship on 22/12. After a period of 6 months, Lord.
Okay then. It may
I'm not
may
on merit
take
at
time
this
and I
place,
don't know.
Lordship. I'm not aware regarding the pendency of the case, Lordship. And now I am ready to appear.
Oh.
So some protection, Lordship, for recalling of the ambiguous as well as the.
Not here,
Yeah,
this stage, why he will have to show what is wrong in the order.
Hmm.
What is wrong in the order, and this court cannot just come into the conclusion in a order which has been passed legally.
So, Lordship,
One fine day, he will come and say this, I am ready to appear. It's not the way.
due to inaction of the executing agency, Lordship.
Yes.
That is why the courts are compelled to pass the NBW as well as the PNA, Lord. Which is evident from the reports
The
also.
PNA, my lord, he came to know that PNA has been issued. And before that, he was not
But
there.
it was informed by one of my friend, Lordship.
Yeah,
I have
but
categorically
that is-
stated, even if Lordship, I am in my petition, Lordship.
Hard Mr. P.K. Gopal and also the petition. So hard Mr. Anna Mr. Leland. So we went. And I think we ordered it. Next, it is submitted by Mr. Gogoi that the present accused petition was shown as an absconder in the charge, but he was not aware about the dependency of this case. Police never searched for him during the investigation. Further, submitted that no summonses were received personally by the present accused person. And without considering this aspect, the NPWA was issued against him petition. And finally, the PNA is also issued against him. However, he is still ready and willing to contest the case by appearing before the learned trial committee. If some interim protection is provided. If further submitted from the charge sheet itself, it is seen that he was searched by police only after 6 months of lodging of the FIR, and there was no such attempt made by the I during the investigation. Mr. Kaushik Ilane people from the order sheets. The annexures as well as from the order sheets. So reveals that the on the accused initially the summons were issued to the accused person, but as returned unexecuted. The court had to issue a BW considering the delay in disposal of this case. And finally, considering his absence, the PNA had to be issued on the basis of report submitted by the executive officer. Mr. Kaushik accordingly submitted that no illegality has been committed by the learned court below by issuing the NPW as well as PNA against the presentation. So at the stage when court had issued the PNA and NPW, there cannot be any interim protection or any order cannot be any order, or there may not be any order for interim protection of the president. Next, by hearing the submission made by the counsel for both sides, I have also produced the case record of the annexures filed along. From the record, it is seen that the accused was shown as an abscond charge sheet. And after non-execution of the summons, the NBWA had to be issued. NBWA had to be issued by the learned court below. And it also reveals that the NBWAs were issued since 2012, 2020. And in spite of several attempts made by the court, the petitioner could not be apprehended. And finding no other alternative, the order of issuance of PNA had to be passed by the land. Further from the charge sheet, it is seen that the IO also made several attempts to apprehend the accused prisoner during the investigation, but it seems that he was avoiding police arrest and did not cooperate in the investigation. So considering overall conduct of the investigation, I do not find it justified to pass any interim protection in the present case. Accordingly, and nor there is any illegality committed by the learned court. But however, petitioner is at liberty to approach the learned trial court below with an appropriate application of bail, which may be considered in accordance with the above observation in present petition stands. Your interim petition cannot be provided to you at this stage. However, you are at liberty to approach the learned. If there is any order, adverse order, you can approach this court. There's no interim. This court.
Well, in this case, the petitioner will come up for passing of the FIR, the charge sheet, and without the order taking cognizance. Well, basically on the ground that may not, firstly, that may not, the first charge sheet was filed against Partha Bharadwaj with the main accused in this case.
Initially,
Yes.
charge
Against
sheet
him,
was filed.
charge sheet was filed.
Acha.
Charge sheet was filed against him, my lord, and then, my lord, cognizance was taken. And thereafter, the matter proceeded, copies were served to him, and, my lord, the trial started. Charge was framed against him, my lord. Only against him, my lord, my lord. Though in the FIR, my lord, there were other persons also, including the petitioner. My lord, charge sheet was filed against him, and, my lord, the matter proceeded, and, my lord, so far Partha Bharadwaj is concerned, my lord, the case is pending, my lord, for evidence, my lord. On 2 occasions, the, my lord, informant was, my lord, called, but he did not appear, and the matter is still pending for recording evidence. In the meantime, my lord, another charge sheet was filed, wherein, my lord, the petitioner and another person K.R. Nagappa were charge sheeted. And, my lord, after receiving of the charge sheet, my lord, cognizance was taken against us. Both the persons, the petitioner and the another person. Now, my lord, in the meantime, having come to know about the fact, my lord, that, my lord, I filed an application before the trial court because someone was not received by me. I filed an application seeking time for my appearance. That has been allowed, my lord. The matter is fixed on 26th of September. My lord, the basic issue, my lord, are 2. Firstly, that my lord will kindly see that first charge sheet was filed. If your lordship kindly may take to the FIR first, my lord. FIR at page 94, my lord. It starts with 89, my lord. Earlier part is in the form. The complaint, it was lodged on, my lord, 19/1/2024. The complaint regarding fraudulent activities of Partha Bharadwaj, Mata Autonomous Council, Dibrugarh, Assam, so and so and so and so and so, so and so and so. My name is M.V. Srinivasalu. And other unknown persons inter alia for the commissions of serious cognizable offence under section 255, 256, 257, 259, 260. There are various, my lord, cheating, impersonation, misappropriation, and then, my lord, 471, 472, 474, 120B of 34 of the Indian Penal Code. Now, my lord, Deepak Chabi has filed this complaint, which has been registered as an FIR, my lord. Now, my lord, what happened in this case, that this Partha Bharadwaj, he was made an advisor of the Matak Council. Now the investigation says that he was not he was not authorized to do it. That Dilip, क्या नाम है उसका? Deepak? No, Deepak Tyagi. The person who given the authorization, he was not authorized to give that, and that was given illegally and all that. But taking that order that he has been advisor, he did what happened. He met with certain persons and all that he can give he can float tender without even giving the tender. He can give the work orders and all that, and accordingly he took the money, security deposit, and issued the work orders. Goods were supplied, payments were not made. If your lordship kindly now, my lord, after this FIR was closed, now, my lord, in this FIR, my lord, nothing has been alleged as against me, my lord, so far impersonation is concerned, so far, my lord, cheating is concerned, so far, my lord, knowing, my lord, any offense under section 471 or anything, my lord. Only 120B is there. Now, your lordship will kindly come to page 96. Page 5, para 5.1. At the residence in Jasola, Delhi, my lord, your lordship will 5.1, third line. Delhi, M.B. Thakur introduced me with V. Srinivasalu. R.B. Thakur introduced with V. Srinivasalu is the petitioner before my lord. Is an old associate of Rajesh Bansal who can get our society work order from Mata Kotomandalam Council and other departments. Then next page, page 97, para 5.2. These are the my lord allegations made in the FIR. I'm not reading the entire FIR. It's a big one, volume aspect. Now, my lord, if your lordship kindly 5.2, fourth line. Therefore, on 28/2/2003, I went to Dibrugarh and the same day met Rajesh Bansal at the office of Mata Council. Dibrugarh, where aforesaid me was so and so was present, and I was introduced to Mr. Nagappa Kurupan. I was told by all of them that so and so and so and so are the liaising agent for procurement and facilitation of purchase orders of Mata Autonomous Council Dibrugarh. Mr. So and so confirmed the aforesaid to me. Mr. Rajesh Bansal and Mr. V. Swarno so and so told me that they work as a team. Thereafter, V. Srinivasalu and Nagappan Kurupan scheduled by meeting on ITNA with the concerned officer of Messrs. Matak Council, Dibrugarh, Assam. Next, my lord will kindly find then page 98. Para 5.6. Mr. Nagappan Kurappan and Mr. V. Srinivasalu and Mr. Rajesh Bansal followed up with me for the meeting fixed with Mr. Partha Bhardwaj on ITNA at the office of Matak Council in the Guwahati, Assam, and they accompanied me for the meeting on 1/2/2003, where we met Mr. Partha Bhardwaj. Then my lord will kindly come to directly page 101. Meanwhile, Mr. Partha Bhardwaj, Rasendra so and so, Thakur, Rajesh Bansal so and V. Srinivasalu continued to raise demand for the remaining security deposit. My lord, the 5% security deposit partly he has paid to Partha Bhardwaj. Remaining, he says that we have raised demand for remaining. 5.12. In the first week of April, Mr. So and so informed me that Partha Bhardwaj would be coming to Delhi in the third week of April to collect the remaining balance of the security amount. Consequently, on 9th April, Partha Bhardwaj, his wife so Nagappan so visited my place. I handed over the case amount so and so to Mr. Partha Bhardwaj and his wife Sudipta. This amount was given in presence of Anand Srivastava, employee of Subhas Gramodyog Sanstha. Then next page 102. on their persistent 5.14, my lord, on their persistent demand of on 24th of April 2003, case amount of rupees so and so was handed over to so and so during our meeting held at Nehru Place. National Federation of so and so processing the corporation of India, where they took me to getting the progress so and so registered with this amount was given in presence of my driver Sanjay Kashyap. Now, these are the allegations. Besides that, nothing is there, my lord. Now, my lord, the charge sheet was filed. If your lordship kindly come to page 109. This charge sheet was filed against नाम कहाँ है देखो पार्थो page 114 your lordship will find. Name is my lordship got it, madam. No charge sheet was filed with any other persons. This charge sheet was filed on 20th of July 2024. Now, if your lordship kindly, I'll just pinpoint another important aspect. ये तो फाइलिंग किया था ना मतलब 136 page 136. My lord, I'm not taking the entire charge sheet to filing. One 136 16.8, my lord. Middle, my lord, your lordship will find 16.8. In course of
Yes.
In course of investigation of the case, it has been proved that the alleged accused Partha Bhardwaj, Nityananda Sharma of Kiran Block, Sarvodaya Nagar, so and so, was appointed as an advisor of Matak Autonomous Council by the existing council headed by David Chetia, Chief Executive Council, illegally without any approval of the government of Assam, who prepared false documents using seal stamp of the council and thereby order for supplying articles of rupees so and so and so. So the entire allegation, what I am trying to show, that a letter has been given to Mr. Partha Bhardwaj showing that he has been appointed as an advisor. Now, on the basis of that, he did all this. And against him, so far he is concerned, there are 4 or 5 cases are there. Even this, one of the accused here, he has also lost an FIR because he was also cheated. In fact, we are also duped in this entire case. Now, my lord, after filing this charge sheet, well, there was a prayer at page 137. Page 137, 16.11, my lord.
Yes.
Further investigation, it has been found that remaining FIR named accused persons and other accused persons are required, which is now under process. Some of the accused persons are yet to be arrested. Under the above circumstances, this prayer is submitted before the Honorable Court to accept the charge sheet submitted against the above named accused persons with a prayer to allow to continue further investigation. Under 173(8) of CRPC against the remaining FIR named accused persons and others to conclude the investigation of the instance. The prayer was made, my lord. I am on basically on this matter. Under 173(8), the police has a right to further investigate into the matter. There is no doubt about that. Now, for that, the apex court has laid down the law that they have to take a permission from the court. The trial magistrate has to pass an order that further investigation can be done. In the instant case, no order of further investigation was passed. I'll place the orders, my lord, before my lord. Now, my lord will kindly come to page 139. In this charge sheet, which is an additional charge sheet, this is additional charge sheet filed on 30/12/2024. My lord will get the date, my lord, in the page 139 itself. Under 120B, 417, 419, 420, 406, 465, 467, 468, 471. Now, my lord, this charge sheet was filed against two persons. One of the petitioner at page 145, your lordship will find. What is the name? 144 and 145. Nagappa is in 144, and my lord, my name appears, petitioner's name at 145. My lord, it is a verbatim of the, my lord, the earlier charge sheet file. Nothing new, my lord. The witnesses cited there, some out of some are cited for them also. No new material. Whatever document they have seized, whatever, my lord, the forensic laboratory examination and all that, the same materials are there, my lord. Now, may take to my lord directly. I'll come to the other aspect, my lord, later on. My lord will come to page 334.
Okay.
334. My lord, you kindly see case record containing charge sheet is put in the charge sheet submitted by against accused Partha Bhardwaj, including 2 sketch maps so and so and so and so, an FSL certified copy so and so. However, original CD is not forwarded to PS. Call for the CD. Case is made over to the court, sell for disposal. So next page, page 335. CR received on transfer without CD for disposal. Peruse the case record. The IO's case has filed the charge sheet. So perusal of this also same is accepted. The record shows that accused person is in judicial custody in view of the materials available before me. Cognizance is taken under the sections of offence raised against the aforesaid accused. Now, what I'm trying to show from this, my lord. Though prayer was there, my lord, in the charge sheet, no separate application was filed. Even assuming that prayer is there, my lord, no order was passed by the trial court, giving them permission to, my lord, make further investigation. I'll come, my lord, further investigation only for the purpose of getting further materials, if any, my lord. Not for the purpose of whatever charge sheet they have filed. They could have charge sheeted him in that itself. Now, Lord, your lordship, next, page 336. Case is ready. Order dated 30/8/2024. Case is ready and same is furnished to the accused person. Page 336. 336.
336.
Well, this is order dated 38.
38.
But I am just showing, my lord, copy is ready and furnished to the accused person. Next, my lord will kindly come to page 337.
So against that Bhardwaj, the complaints has been taken and the case proceeded.
Case proceeded and, my lord, charge has been framed.
Charge has been framed.
My lord, my submission will be, my lord, the trial is started.
Yes.
Trial is started, my lord. This is my submission to show from there. Now, my lord will come to page 338. And the case is at the stage of trial. Once, my lord, charge is framed, my lord, the trial begins, my lord. That is the law. I did not, my lord. Now, my lord, 3/1/2025 is order dated page 338. Additional charge sheet along with the documents in connection with so and so has been submitted by IO. File charge sheet, white charge sheet number so and so against so and so and so. Since the peruse the entire records accordingly, cognizance of offence under section so and so have been taken against the accused persons are so and so and Sri so and so. So against me, my lord, the cognizance was taken on 3/1/2025 for production of accused Partha Bharadwaj, appearance so other my lord. So my lord, this order is under challenge before this my lord. Now, my lord, may I take to my lord section 173(8), my lord. Okay, yeah. हमारी किताब है ना?
What are you reading for? 5? Section?
CRPC my lord 173.
CRPC section?
Says
Oh, okay, one. Yes.
nothing in this section shall be, my lord, no, 8, no, subclause 8.
Yes.
Nothing in this section shall be deemed to preclude further investigation in respect of an offence after the report under subsection 2 has been forwarded to the magistrate. And where upon such investigation, the officer in charge of the police station obtains further evidence. Your lordship will kindly see this is very important. Officer in charge of the police station obtains further evidence, oral or documentary. He shall forward to the magistrate a further report or reports regarding such evidence in the form prescribed, and the provisions of subsection 2 to 6 shall, as far as may be, apply in relation to such report or reports as they apply in relation to report forwarded under subsection 2. So, my lord, I'm saying that they are not precluded not for further investigation. Now, my lord, the apex court. Report to the court. Don't issue BN से आगे दे दो कर. और in 2013 5 SCC, I'm giving it. My lord, I'll be not troubling my lord to read the entire. In this case, my lord, further investigation, fresh investigation.
Basically,
all
emphasize on para, which para?
para, my lord, I'll come to directly 40.6, my lord.
Four?
Page 790, 40.6, my lord.
Seven nine zero 14.6. 14.6 para is not there.
40, my lord. 40, my lord, 0.6, my lord.
40.
Yes, my lord. Your lordship will kindly see 40. Having analyzed the provisions of the code and the various judgments as indicated,
Yes.
we would like to state the following conclusion with regard to the power of magistrates in terms of section 173, read with section 173(8) and 156(3). My lord, I'm leaving this earlier, 40.2. A magistrate has the power to direct further investigation after filing of the police report in terms of section 173 of the code. Now, neither the scheme of the code nor any specific provision in bar exercise of such judicial message, the language of section 173 cannot be construed so restrictively as to deprive the magistrate of such powers, particularly in the face of the provisions of section 156(3) and the language of section 173 itself. In fact, such powers would have to be read into the language of section 173(8). Now, 40.6. It has been a procedure of propriety that police has to seek a permission of the court to continue further investigation and file supplementary charges. This approach is approved by this court in number of judgments. This as such support the view that we are taking in the present case. So, my lord, 173(8) does not specify that while making further investigation, my lord, the police has to take the permission. But my lord, by judicial pronouncement in 79 Supreme Court also, my lord, in Ramlal Narang, para 2021, this was an earlier decision that has also been considered here, my lord. My lord, may I read para 21 of this judgment? (21) As observed by us earlier, there was no provision in the CRPC 89 which expressly or by necessary implication barred the right of the police officer to further investigate after cognizance of the case had been taken by neither section 173 or nor section 190 did us by the magistrate taking cognizance. Practice, convenience and preponderance of authority permitted repeated investigation on discovery of trace facts. In our view, notwithstanding that a magistrate had taken cognizance of the offence upon a police report submitted on so and so, the right of the police to further investigate was not exhausted, and the police could exercise such right as often necessary when fresh information came to light. Where the police desired to make a further investigation, the police could express their regard and respect of the court by seeking its formal permission to make further investigation. Earlier in para 20 also, my lord, if your lordship, can you look into it was a case. My lord, the power in the middle, my lord will kindly see. Anyone acquainted with the day-to-day working of the criminal? I'm not on my lord. My lord will kindly see line about 15. If he has already taken cognizance of the West, but has not proceeded with the inquiry or trial, he may direct the issue of process to person freshly discovered to be involved and deal with all the accused in a single inquiry or trial. If the case of which he has previously taken cognizance has already proceeded to some extent, he may take fresh cognizance of the offence, disclose against the newly involved accused, and proceed with the case as a separate case. Well, this is one aspect of the matter. My submission is that, my lord, this will come later on. In this case also, my lord, the trial began. And my lord, the permission was not granted to make a fresh further investigation. So in that
where
view,
from you are saying?
you know,
Permission is required, where from you are saying?
you know,
Prior permission required, which line you are indicating?
my lord,
From which line you want to on this submit that a prior permission is required? From where? Which
Well,
para?
para 40.6, my lord. Para 21 also.
Where?
My lord, para 21. Last three line, where the police desire to make a further investigation, the police could express their regard and respect for the court by seeking its formal permission to make further investigation.
There was a prayer, in fact. Anyway, okay, yes.
So, my lord, my submission is that firstly, they violated this section 173(8). And this was, my lord, further, my lord, approved in the three judges bench in, my lord, later on, my lord. Besides that, my lord, your lordship will kindly see that we both the informant and, my lord, the petitioner before my lord, they work together. Your lordship will kindly find, I'll just show the page. Oh, is fine. My lord, your lordship will kindly come to page 73.
Yes.
Your lordship will kindly, there is a partnership between the Deepak Tyagi, next page will be, my lord, your lordship will find page 78. My lord, Deepak Tyagi and so, who made one 21st day of March 2023. Then thereafter, my lord, there were certain, my lord, disputes in between them. The lordship will find
Now, see, it's okay that you are a partner, but you have a partnership firm or that you were working together. And it seems that the FIR also, it reveals that in FIR, there was some allegation brought against you. You are the name accused.
My lord.
But the question is whether at the time of the preliminary investigation, they immediately filed charge sheet against one Patho Bhardwaj and all. And there was a specific prayer from the side that against you 3 or 4 petitioners, the investigation is still under progress. That was there in the charge sheet itself.
Lord.
That we are going to file the subsequent search it because
Lord,
there
where is there, my lord?
investigation is there.
Lord, your lordship,
are coming on
your
the
lordship made one
technicality.
thing, my lord. My lord, I have found, my lord, today I have not been able to place the judgment where they say that the, my lord, permission is required. I'll place that judgment. If your lordship can take it on Monday, my lord.
No, you have heard it long, it may not be possible on Monday. There are lots of matters being fixed. What remains, what we want to submit again?
My lord, that, my lord saying that these are the, my lord, in this para, whatever I have cited, my lord is saying that this
No,
is.
no, in para 21, there is one sentence, I think.
No, that has been discussed, my lord, that I have not read the entire because, my lord, time is short, other persons are sitting. Other matters are pending, that's what, my lord is like at 3:15, my lord. So I have not placed the entire paragraph. It specifically says that for the sake of the property, they have to seek the permission.
Not may be possible. So, hold on.
Monday or Wednesday, whichever day. If Monday not possible, Wednesday, my lord.
Absolutely. কি হলো একটা সাইড time He's saying that at best it can be listed on Wednesday. Mr. Goswami, you remain present on Wednesday also.
I'll present.
You, if have any submission or any citation is there, in that
Yes,
it can come.
Wednesday.
Otherwise, I have
Ah.
noted down. Now say, don't repeat these things.
No, no, it's all
because I
right.
have
My
noted
lord
down all
my
these
lord may
things.
keep part heard also, my lord. I have no objection, my lord.
Part had may not be because
Ah.
there may be again some difficulty.
I'll-
So otherwise, I have noted down everything in
Yes,
your
yes.
submission. So rather page wise also, it is written. So we are listing it on Wednesday. To make a further submission in regards to only
Well, I'll
prior
get-
permission, if required or not. That much only. Otherwise, rest of the submission I have already. Mr. The other one, Ivan Senior, assisted by Mr. Maheswari.
D Rati.
Huh?
D Rati.
D. Rai.
Rati.
Rati. D. Rai.
Rati.
D. Rati. Mr. MP Gupson, learned petition people. Considering if they are submitted by Mr. Durga, the matter will be listed on Wednesday. In the motion column itself. Okay, we are listing it on Wednesday. Right.
May it please your lordship. In this matter, my lordship, the petitioner name was shown as an absconder in the charge sheet. As well as the court also observed that he is absconding. After getting the summon, my lord, he came to know all these things, that there is a
Whether
case.
there's any observation from the court?
Observation, my lord,
Where is the
on the basis of the,
Now,
charge
see,
sheet.
now all the courts are following one principle that even if, I mean, the police officer has no authority to make any person as an absconder, declare
Yes.
any person.
Yes.
So considering this aspect, every court is now issuing summon, not directly
No,
NBW.
kindly see that order, my lord. Kindly say page 40.
Huh?
Page 40, my lord.
114,
40.
40.
Annexure 3.
Last question.
Yes.
That's case record is received for trial and disposal, so and so, so and so. Accused Foizul Islam, accused number 7 is shown as an absconder. This observation
Shown as an absconder.
is shown,
What harm?
that is why, my lord, the petitioner is afraid to appear before the,
What is harm?
No,
You're
I'm-
showing as an absconder is a true fact.
Yes.
That's what is reflected in the order.
that is why, my lord, this petitioner approached before this court to, appear before the court to file an appropriate petition. That petition may be considered, my lord.
No,
That
at
is
this
my
case,
appeal.
whether any, apart from summon, whether NBW is
No,
also
no,
issued
no,
against you?
no, no.
Only someone.
Which
Only
is the
summon,
last
that-
order? Which is the last order?
That is the last order, effective order.
I don't
Thereafter.
think so, because it is passed on,
Yeah.
in the month of March.
Next date was fixed on 26/25 as per this order.
As per this order.
As per this, and there is another order, my lord. That order also, my lord,
Summon.
summon was issued.
So you have
but-
received the summon now.
After received the summon, he came to know these things.
What thing? That you have shown as an absconder.
Yes, my lord. My lord, no police personnel came to my house nor arrested me, no notice was given. That is why, my lord.
Only
before
someone
this-
has been issued, he can appear, he can go. and-
Yes, I am appeal, but
Otherwise, my lord,
This is a case of fake currency.
Take
take currency,
Mana, only
Your
thing
Honor.
is
But
that-
I am the petty cultivator, my lord. But I am saying.
Apart
for-
from the cultivation, you also. keep
No,
this
no,
fake
no,
currency.
my lord. That is why. My lord, there is no materials against me, my lord.
Okay.
As per the charge sheet as well as the in FIR showing. Whatever materials is collected that the other person, my lord, not from me. That is why, my lord, I am not delaying the matter. I am trying to appear to defend my case. So that my application may be considered, my
Police
lord.
doesn't declare absconder, my lord. They write it in the literal sense, my lord. They are not finding. That is not a.
That is why, my lord,
declaration as per se.
nobody, because, my lord,
That's it.
the problem is some magistrate learned courts are not able to understand these things. They may be.
No, he or she has very well understood.
No. He is understood. My lord, that the petitioner's point of view we are saying.
Petitioner's point of view.
Petitioner's point of view, because he is afraid to appear because because
that may be that.
that is why. That is why he appears before.
You are Mr.
NC Das.
Heard Mr. Ansidas, denied also the petition. And also heard Mr. R.R. Ghosh, denied petition. Being on behalf of the petition,
Yeah, no তারিখ আছে
order against rights. as
9
side, telling it the order.
6 তারিখ আছে
Telling it, order to sense proof লাগাবে।
সোসাইটি পাশে পয়সা ফাইল করে
তো sense proof লাগা order এ না।
এই অর্ডারটা অনামে মিছিল কিবা আমি নকৰি না
Oh, it order says, order sending the order of 26/3/2025 and 20/06/2025 passed in PR case number 161. Pending, passed by learned SDTN, Korea Board. No. It is,
My lord, next date is fixed of 6/9/2021. Next date.
submitted by Mr. Das that present accused petitioner is innocent and he has not committed any such offense allegedly at trial. Nothing has been seized from the person of the accused petitioner, and he was not aware about dependency of the case. During the investigation, police never searched for the present petitioner, and hence he could not cooperate in the investigation of this case. However, he is ready and willing to appear before the learned trial court below and to confess the case clearly if he is provided with some information. Next, para Mr. Kaushik, the learned additional people submitted in this regard that there is no illegality has been committed by the learned court below, and only summonses were issued against the present petitioner, directing him to appear before the court below. Thus, there cannot be any interim protection for the present petitioner. Next, hearing the submission made by the citizens and considering all aspects of the case, I find that some interim protection may be provided to the petitioner. And according and with a direction to appear before the learned trial court with an appropriate application for bail, which may be considered in accordance. Yeah, however, from the your next date is on 6/9.
Next is 6/9.
However, till 6/9/2025, that is the next date fixed by the learned court below, no coercive action shall be taken against the present petitioner. Now, see, it is not a case that you are against you any NBWL issues, so we cannot suspend or stay any NBW. But however, we have a give a direction in kind of interim protection that
Yes.
no coercive action shall be taken against you. No coercive action shall be
Yes.
taken against you. That much. Till 6/9. Till next. Just put. Not good. So the other matters will be adjourned. We cannot provide any fixed date for any matters except the matters wherein any interim protection was there. That much. Otherwise, no.
Much of
The next item is small order is request. Case is pending for more than 5.5 years. Only disposal my 127 petition. It will hardly 2 minutes, like your lordship, 2 minutes.
Otherwise, everything is said. It can be heard on so long.
My lord,
Why it is pending for
5.5 years, 127 petition. So my prayer is this petition will be disposed, directing the court below to dispose of my petition.
Will take another 10 minutes. We have to rush. I will put case before it is there. So, if any interim, I'm just repeating, if any interim is there, then definitely will cooperate, will accommodate by giving it the rest of the matters will be all left over, considered to be left. We don't have any.
Lordship, in 30 and 31, may I pray for a fixed date, Lordship, 6/25.
That we cannot say. For you only cannot be fixed yet. For everyone, there is a honor waiting. So again, in that case, if you fix any date, it will come again this court, and again it will be left over only. So rest you will definitely accommodate.
My lord, 27 is a admission, criminal appeal admission matter, my lord. Accused are to be on bail, my lord. So may I say the matter may be taken on the 4th of 5th, my lord.
No, we are not fixing any date. That's what I'm saying. Wherein only the interim question of interim is there, that much will be answered. Other rest are.